Record, that's a rate of 7,000 pages.
And we're heading back now live for opening statements in the Brett Kavanaugh Supreme Court confirmation hearing. We'll be showing each day's testimony during prime time on C-SPAN 2 if you miss any of our live coverage.
Before I call on first of all, thanks, Judge Kavanaugh, for getting back on the exact time. Before I call on Senator Klobuchar, I think that some of my colleagues have raised some issues that I demand an answer, and I want to speak to those points. But this issue's never come up from my colleagues, but I thought, as I sat here and listened to some people criticize the Supreme Court for, in a sense, being bought, and they always tend to criticize the President of the United States for somehow interfering in the judiciary, and I hear all about the criticism of Trump. It seems odd to me that we don't have criticism of people that are saying the same thing about the Supreme Court. So I want to read, whenever the President criticizes the judiciary or judicial decisions, we hear wails of anguish from my Democratic colleagues. They attack the President for threatening the independence and the integrity of the judiciary, and they applaud the judiciary for standing up to the President. I just listened to some of my colleagues here. One of them spent 18 minutes attacking the personal integrity of justices of the Supreme Court. He said that 5 justices have been bought and sold by private interests. He accused them of deciding cases to the benefit of favored parties. So I think it's pretty clear, a double standard, and we shouldn't have to tolerate such double standard, and particularly from a press that is the policeman of our whole democratic process, that without a free press, our government would be less than what it is. And it seems to me that that's something that I hope somebody will take into consideration. Probably won't, but at least I said my piece. Then also, several senators have brought up about the 6% and the 99% and things like that I thought I ought to clear up, because I could say myself that when I first started finding out how much paper Judge Kavanaugh had on his record, I mean, for his background, I started talking about 1 million pages. And then when we finally get 488,000, then I could say, well, I got about 48% of what we ought to have. But there's a good explanation why we don't have it. So I want to read. Some of my colleagues keep saying that we have only 6% of Judge Kavanaugh's White House records, but that 99% of Justice Kagan's White House records were made public before the hearing. This is fuzzy math. My colleagues calibrate their phony 6% figure on 2 inaccurate numbers. First, their 6% figure counts the estimated page count by career archivists at the National Archives based upon their historical practice before the unprocessed emails and attachments are actually reviewed. When Judge Kavanaugh's White House emails that we've received, the actual number of pages ended up being significantly less than the number the National Archives estimated before the actual review. One reason is because we were able to use technology to cull out the exact duplicate emails. Instead of having to read 13 times an email that Judge Kavanaugh sent to 12 White House colleagues, we only had to read the email once. Second, the 6% figure counts millions and millions of pages of irrelevant staff secretary documents that we never ever requested or needed. More importantly, we received 100% of the documents we requested from Judge Kavanaugh's time as an executive branch lawyer. And while we may have received 99% of Justice Kagan's White House records, we received 0 records from her most relevant legal service as a Solicitor General, the federal government's top Supreme Court advocate. We received much less than 99% of her records as a lawyer. And we didn't receive 60,000 emails from Justice Kagan, so 99% is an overestimate. And even though we never received them, Justice Kagan's Solicitor General records were much more needed at the time because Kagan was a blank slate as a judge. Instead, unlike Judge Kavanaugh, with his 12 years of judicial service and over 10,000 pages of judicial writings on the nation's most important federal circuit court, Justice Kagan had 0 years of judicial service and 0 pages of judicial writing before her appointment to the highest court. Senator Klobuchar.
Well, thank you, Mr. Chairman. And before I begin my opening statement, I just wanted to respond to just a few things. One, none of that takes away from the fact that 42,000 documents were dumped on us last night, and I don't think anyone would go to trial and allow a trial to go forward or allow a case to go forward if one side got 42,000 documents the night before and the other side, and you can't simply review them. As pointed out by Senator Whitehouse, you'd have to review 7,000 documents every hour. That happened last night.
Let me respond without taking time away from you.
Thank you.
You Democrats got exactly the same amount of money we did to do the work, the massive amount of work we had to do. And we got it done at 11 o'clock last night.
The
Proceed.
point is that no one could prepare and review 42,000 documents in one evening. We know that, no matter how much coffee you drink. And the second point is that it is true that executive privilege has never been invoked before to block the release of presidential records during this, to the Senate during a confirmation hearing. So I will begin my opening statement, but those are 2 points I don't believe are refuted. So.
Okay, well, I'll refute it from this standpoint. There were 5,000 documents, 42,000 pages.
Okay.
Proceed.
Thank you. Welcome, Judge Kavanaugh. We welcome your family as well. On its face, this may look like a normal confirmation hearing. It has all the trappings, all of us up here, all of the cameras out there, the statements, the questions, all of it looks normal. But this is not a normal confirmation hearing. First, as we have debated this morning, we are being asked to give advice and consent when the administration has not consented to give us over 100,000 documents, all of which detail a critical part of the judge's career, the time he spent in the White House. And in addition, the majority party has not consented to make 189,000 of the documents we do have public. As a former prosecutor, I know that no lawyer goes to court without reviewing the evidence and record. I know, and I know you know, Judge Kavanaugh, that a good judge would not decide a case with only 7% of the key documents. A good judge would not allow a case to move forward if one side dropped 42,000 pages of documents on the other side the night before the case started. And yet, that is where we are today. This isn't normal. It's an abdication of the role of the Senate and a disservice to the American people, and it is our duty to speak out. Secondly, this nomination comes before us at a time when we are witnessing seismic shifts in our democracy. Foundational elements of our government, including the rule of law, have been challenged and undermined. Today, our democracy faces threats that we never would have believed would be occurring not that long ago. Our intelligence agencies agree that a foreign adversary attempted to interfere in our most recent election, and it's happening again. In the words of the President's Director of National Intelligence, the lights are blinking red. There is an extensive ongoing investigation by a special counsel. The President's private lawyer and campaign chairman have been found guilty of multiple federal crimes. The man appointed as special counsel in this investigation, a man who has served with distinction under presidents from both parties, has been under siege. The dedicated public servants who work in our Justice Department, including the Attorney General and the FBI, have been subjected to repeated threats and have had their work politicized and their motives questioned. In fact, just this past weekend, federal law enforcement was called out, was rebuked by the President of the United States for simply doing their jobs, for prosecuting 2 white-collar defendants, one for insider trading, one for campaign theft. Why? Because the defendants were personal friends and campaign supporters of the President of the United States. As a former prosecutor, as someone who has seen federal law enforcement do their jobs, this is abhorrent to me. So no, this is not normal. And the last branch, the third branch of government, our courts and individual judges, have been under assault, not just by a solitary disappointed litigant, but by the President of the United States. Our democracy is on trial. And for the pillars of our democracy and our Constitution to weather this storm, our nation's highest court must serve as a ballast in these turbulent times. Our very institutions and those nominated to protect these institutions must be fair, impartial, and unwavering in their commitment to truth and justice. So today we will begin a hearing in which it is our duty to carry on the American constitutional tradition that John Adams stood up for many centuries ago. And that is to be, in his words, a government of laws and not men. To me, that means figuring out what your views are, Judge, on whether a president is above the law. It is a simple concept we learned in grade school, that no one is above the law. So I think it's a good place to start. There were many highly credentialed nominees like yourself that could have been sitting before us today. But to my colleagues, what concerns me is that during this critical juncture in history, the President has handpicked a nominee to the court with the most expansive view of presidential power possible, a nominee who has actually written that the President, on his own, can declare laws unconstitutional. Of course, we are very pleased when a judge submits an article to the University of Minnesota Law Review, and even more so when that article receives so much national attention. But the article you wrote that I'm referring to, Judge, raises many troubling questions. Should a sitting president really never be subject to an investigation? Should a sitting president never be questioned by a special counsel? Should a president really be given total authority to remove a special counsel? In addition to the article, there are other pieces of this puzzle which demonstrate that the nominee before us has an incredibly broad view of the president's executive power. Judge Kavanaugh, you wrote, for example, in 7 Sky v. Holder, that a president can disregard a law passed by Congress if he deems it to be unconstitutional, even if a court has upheld it. What would that mean when it comes to laws protecting the special counsel? What would that mean when it comes to women's health care? The days of the divine rights of kings ended with the Magna Carta in 1215. And centuries later, in the wake of the American Revolution, a check on the executive was a major foundation of the United States Constitution. For it was James Madison, who may not have had a musical named after him, but was a top scholar of his time, who wrote in Federalist 47, The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. So what does that warning mean in real-life terms today? Here's one example. It means whether people like Kelly Gregory, an Air Force veteran, mother, and business owner who is here from Tennessee and who is living with stage 4 breast cancer, can afford medical treatment. At a time when the administration is arguing that protections to ensure people with pre-existing conditions can't be kicked off their health insurance are unconstitutional, we cannot and should not confirm a justice who believes the president's views alone carry the day. One opinion I plan to ask about: when judges appointed by presidents of both parties joined in upholding the Consumer Financial Protection Bureau, you, Judge, dissented. Your dissent concluded that the Bureau, an agency which has served us well in bringing back over $12 billion to consumers for fraud from credit cards to loans to mortgages, was unconstitutional. Or in another case, you wrote a dissent against the rules that protect net neutrality, rules that help all citizens and small businesses have an even playing field when it comes to accessing the internet. Another example that seems mired in legalese but is critical for Americans: antitrust law. In recent years, a conservative majority on the Supreme Court has made it harder and harder to enforce the nation's antitrust laws, ruling in favor of consolidation and market dominance. Yet 2 of Judge Kavanaugh's major antitrust opinions suggest that he would push the court even further down this pro-merger path. We should have more competition and not less. Now, to go from my specific concerns and end on a higher plane. All of the attacks on the rule of law in our justice system over the past year have made me, and I would guess some of my other colleagues on this committee, pause and think many times about why I decided to come to the Senate and get on this committee, and much further back, why I even decided to go into law in the first place. Now, I will tell you that not many girls in my high school class said they dreamed of being a lawyer. We had no lawyers in my family, and my parents were the first in their families to go to college. But somehow my dad convinced me to spend a morning sitting in a courtroom watching a state court district judge handle a routine calendar of criminal cases. The judge took pleas, listened to arguments, and handed out misdemeanor sentences. It was certainly nothing glamorous, like the work for the job you've been nominated for, Judge, but it was important just the same. I realized that morning that behind every single case, there was a story and there was a person, no matter how small. Each and every decision the judge made that day affected that person's life. And I noticed how often he had to make gut decisions and had to take account of what his decisions would mean for that person and his or her family. This week, I remembered that day, and I remembered I had written an essay about it at the ripe old age of 17. I went back and looked at what I had said. It is something that I still believe today, and that is that to be part of an imperfect system, to have a chance to better that system, was and is a cause worth fighting for, a job worth doing. Our government is far from perfect, Judge, nor is our legal system, but we are at a crossroads in our nation's history where we must make a choice. Are we going to dedicate ourselves to improving our democracy, improving our justice system, or not? The question we are being asked to address in this hearing, among others, is whether this judge, at this time in our history, will administer the law with equal justice as it applies to all citizens, regardless of if they live in a poor neighborhood or a rich neighborhood, or if they live in a small house or the White House. Our country needs a Supreme Court justice who will better our legal system, a justice who will serve as a check and balance on the other branches of government, who will stand up for the rule of law without consideration of politics or partisanship, who will uphold our Constitution without fear or favor, and who will work for the betterment of the great American experiment in democracy. That is what this hearing is about. Thank you.
Senator Sass.
Thank you, Mr. Chairman. We need to get to Judge Kavanaugh, but I really want to riff with Amy for a while. Senator Klobuchar, you did Madison, Lin-Manuel Miranda, the Magna Carta, and your dad taking you to court. Well done.
That.
I had all that on my bingo card. I have little kids, and I've taken my 2 little girls to court a few times too, mostly to juvie, just to scare them straight, not to turn them into attorneys. But that's
Who said that that wasn't what my dad was doing, Senator Sapp?
That was wisdom in Minnesota. Congratulations, Judge, on your nomination. Ashley, congratulations and condolences. This process has to stink. I'm glad your daughters could get out of the room, and I hope they still get the free day from school. Let's do some good news, bad news. The bad news first. Judge, since your nomination in July, you've been accused of hating women, hating children, hating clean air, wanting dirty water. You've been declared a quote-unquote existential threat to our nation. Alumni of Yale Law School incensed that faculty members at your alma mater praised your selection, wrote a public letter to the school saying, quote, "People will die if Brett Kavanaugh is confirmed." This drivel is patently absurd, and I worry that we're going to hear more of it over the next few days. But the good news is it is absurd, and the American people don't believe any of it. This stuff isn't about Brett Kavanaugh when screamers say this stuff for cable TV news. The people who know you better, not those who are trying to get on TV, they tell a completely different story about who Brett Kavanaugh is. You've earned high praise from the many lawyers, both right and left, who've appeared before you during your 12 years on the D.C. Circuit, and those who've had you as a professor at Yale Law and at Harvard Law. People in legal circles invariably applaud your mind, your work, your temperament, your collegiality. That's who Brett Kavanaugh is. And to quote Lisa Blatt, a Supreme Court attorney from the left who's known you for a decade, quote, "Sometimes a superstar is just a superstar, and that's the case with this judge. The Senate should confirm him," close quote. It's pretty obvious to most people going about their work today that the deranged comments actually don't have anything to do with you. So we should figure out, why do we talk like this about Supreme Court nominations now? There's a bunch that's atypical in the last 19, 20 months in America. Senator Klobuchar's right. The comments from the White House yesterday about trying to politicize the Department of Justice, they were wrong and they should be condemned. And my guess is Brett Kavanaugh would condemn them. But really, the reason these hearings don't work is not because of Donald Trump. It's not because of anything the last 20 months. These confirmation hearings haven't worked for 31 years in America. People are going to pretend that Americans have no historical memory, and supposedly there haven't been screaming protesters saying women are going to die at every hearing for decades. But this has been happening since Robert Bork. This is a 31-year tradition. There's nothing really new the last 18 months. So the fact that the hysteria has nothing to do with you means that we should ask, what's the hysteria coming from? The hysteria around Supreme Court confirmation hearings is coming from the fact that we have a fundamental misunderstanding of the role of the Supreme Court in American life now. Our political commentary talks about the Supreme Court like there are people wearing red and blue jerseys. That's a really dangerous thing. And by the way, if they have red and blue jerseys, I would welcome my colleagues to introduce the legislation that ends lifetime tenure for the judiciary. Because if they're just politicians, then the people should have power, and they shouldn't have lifetime appointments. So until you introduce that legislation, I don't believe you really want the Supreme Court to be a politicized body, though that's the way we constantly talk about it now. We can and we should do better than this. It's predictable that every confirmation hearing now is going to be overblown, politicized circus. And it's because we've accepted a new theory about how our 3 branches of government should work, and in particular, how the judiciary should work. What Supreme Court confirmation hearings should be about is an opportunity to go back and do schoolhouse rock civics for our kids. We should be talking about how a bill becomes a law and what the job of Article 2 is and what the job of Article 3 is. So let's try just a little bit. How did we get here and how can we fix it? I want to make just 4 brief points. Number 1, in our system, the legislative branch is supposed to be the center of our politics. Number 2, it's not. Why not? Because for the last century, and increasing by the decade right now, more and more legislative authority is delegated to the executive branch every year. Both parties do it. The legislature is impotent, the legislature is weak, and most people here want their jobs more than they really want to do legislative work, and so they punt most of the work to the next branch. Third consequence is that this transfer of power means the people yearn for a place where politics can actually be done. And when we don't do a lot of big actual political debating here, we transfer it to the Supreme Court. And that's why the Supreme Court is increasingly a substitute political battleground in America. It is not healthy, but it is what happens, and it's something that our founders wouldn't be able to make any sense of. And fourth and finally, we badly need to restore the proper duties and the balance of power from our constitutional system. So point one, the legislative branch is supposed to be the locus of our politics, properly understood. Since we're here in this room today, because this is a Supreme Court confirmation hearing, we're tempted to start with Article 3. But really, Article 3 is the part of the Constitution that sets up the judiciary. We really should be starting with Article 1, which is us. What is the legislature's job? The Constitution's drafters began with the legislature. These are equal branches, but Article 1 comes first for a reason. And that's because policymaking is supposed to be done in the body that makes laws. That means that this is supposed to be the institution dedicated to political fights. If we see lots and lots of protests in front of the Supreme Court, that's a pretty good litmus test barometer of the fact that our republic isn't healthy. Because people shouldn't be thinking they are protesting in front of the Supreme Court. They should be protesting in front of this body. The legislature is designed to be controversial, noisy, sometimes even rowdy, because making laws means we have to hash out the reality that we don't all agree. Government is about power. Government is not just another word for things we do together. The reason we have limited government in America is because we believe in freedom. We believe in souls. We believe in persuasion. We believe in love. And those things aren't done by power. But the government acts by power. And since the government acts by power, we should be reticent to use power. And so it means when you differ about power, you have to have a debate. And this institution is supposed to be dedicated to debate and should be based on the premise that we know since we don't all agree, we should try to constrain that power just a little bit, but then we should fight about it and have a vote in front of the American people. And then what happens? The people get to decide whether they want to hire us or fire us. They don't have to hire us again. This body is the political branch where policymaking fights should happen. And if we are the easiest people to fire, it means the only way the people can maintain power in our system is if almost all the politicized decisions happen here, not in Article 2 or Article 3. So that brings us to a second point. How do we get to a place where the legislature decided to give away its power? We've been doing it for a long time. Over the course of the last century, but especially since the 1930s and then ramping up since the 1960s, a whole lot of the responsibility in this body has been kicked to a bunch of alphabet soup bureaucracies. All the acronyms that people know about their government or don't know about their government are the places where most actual policy making, kind of in a way lawmaking, is happening right now. This is not what Schoolhouse Rock says. There's no verse of Schoolhouse Rock that says give a whole bunch of power to the alphabet soup agencies and let them decide what the governance decision should be for the people, because the people don't have any way to fire the bureaucrats. And so what we mostly do around this body is not pass laws. What we mostly do is decide to give permission to the secretary or the administrator of bureaucracy X, Y, or Z to make law-like regulations. That's mostly what we do here. We go home and we pretend we make laws. No, we don't. We write giant pieces of legislation, 1,200 pages, 1,500 pages long, that people haven't read, filled with all these terms that are undefined, and we say the secretary of such and such shall promulgate rules that do the rest of our dang jobs. That's why there's so many fights about the executive branch and about the judiciary, because this body rarely finishes its work. And the House is even worse. I don't really believe that. It just seemed like you needed to try to unite us in some way. So I admit that there are rational arguments that one could make for this new system. The Congress can't manage all the nitty-gritty details of everything about modern government, and this system tries to give power and control to experts in their fields, where most of us in Congress don't know much of anything, or about technical matters for sure, but you could also impugn our wisdom if you want. But when you're talking about technical, complicated matters, it's true that the Congress would have a hard time sorting out every final dot and tittle about every detail. But the real reason at the end of the day that that this institution punts most of its power to executive branch agencies is because it's a convenient way for legislators to be able to avoid taking responsibility for controversial and often unpopular decisions. If people want to get reelected over and over again, and that's your highest goal, if your biggest long-term thought around here is about your own incumbency, then actually giving away your power is a pretty good strategy. It's not a very good life, but it's a pretty good strategy for incumbency. And so at the end of the day, a lot of the power delegation that happens from this branch is because the Congress has decided to self-neuter. Well, guess what? The important thing isn't whether or not the Congress has lame jobs. The important thing is that when the Congress neuters itself and gives power to an unaccountable fourth branch of government, it means the people are cut out of the process. There's nobody in Nebraska, there's nobody in Minnesota or Delaware who elected the Deputy Assistant Administrator of Plant Quarantine at the USDA. And yet if the Deputy Assistant Administrator of Plant Quarantine does something to make Nebraskans' lives really difficult, which happens to farmers and ranchers in Nebraska, who do they protest to? Where do they go? How do they navigate the complexity and the thicket of all the lobbyists in this town to do executive agency lobbying? They can't. And so what happens is they don't have any ability to speak out and to fire people through an election. And so ultimately, when the Congress is neutered, when the administrative state grows, when there is this fourth branch of government, it makes it harder and harder for the concerns of citizens to be represented and articulated by people that the people know that they have power over. All the power right now, or almost all the power right now, happens off stage. And that leaves a lot of people wondering, who's looking out for me? And that brings us to the third point. The Supreme Court becomes our substitute political battleground. It's only 9 people. You can know them, you can demonize them, you can try to make them messiahs, but ultimately, because people can't navigate their way through the bureaucracy, they turn to the Supreme Court looking for politics. And knowing that our elected officials no longer care enough to do the hard work of reasoning through the places where we differ and deciding to shroud our power at times, it means that we look for 9 justices to be super legislators. We look for 9 justices to try to right the wrongs from other places in the process. When people talk about wanting to have empathy from their justices, this is what they're talking about. They're talking about trying to make the justices do something that the Congress refuses to do as it constantly abdicates its responsibility. The hyperventilating that we see in this process and the way that today's hearing started with 90 minutes of theatrics that are pre-planned with certain members of the other side here, it shows us a system that is wildly out of whack. And thus a fourth and final point. The solution here is not to try to find judges who will be policymakers. The solution is not to try to turn the Supreme Court into an election battle for TV. The solution is to restore a proper constitutional order with a balance of powers. We need Schoolhouse Rock back. We need a Congress that writes laws and then stands before the people and suffers the consequences and gets to go back to our own Mount Vernon if that's what the electors decide. We need an executive branch that has a humble view of its job as enforcing the law, not trying to write laws in the Congress's absence. And we need a judiciary that tries to apply written laws to facts and cases that are actually before it. This is the elegant and the fair process that the founders created. It's the process where the people who are elected, 2 and 6 years in this institution, 4 years in the executive branch, can be fired because the justices and the judges, the men and women who serve America's people by wearing black robes, they're insulated from politics. This is why we talk about an independent judiciary. This is why they wear robes. This is why we shouldn't talk about Republican and Democratic judges and justices. This is why we say justice is blind. This is why we give judges lifetime tenure. And this is why this is the last job interview Brett Kavanaugh will ever have, because he's going to a job where he's not supposed to be a super legislator. So the question before us today is not what does Brett Kavanaugh think 11 years ago on some policy matter. The question before us is whether or not he has the temperament and the character to take his policy views and his political preferences and put them in a box marked irrelevant and set it aside every morning when he puts on the black robe. The question is, does he have the character and temperament to do that? If you don't think he does, vote no. But if you think he does, stop the charades. Because at the end of the day, I think all of us know that Brett Kavanaugh understands his job isn't to rewrite laws as he wishes they were. He understands that he's not being interviewed to be a super legislator. He understands that his job isn't to seek popularity. His job is to be fair and dispassionate. It is not to exercise empathy. It is to follow written laws. Contrary to the onion-like smears that we hear outside, Judge Kavanaugh doesn't hate women and children. Judge Kavanaugh doesn't lust after dirty water and stinky air. No, looking at his record, it seems to me that what he actually dislikes are legislators that are too lazy and too risk-averse to do our actual jobs. It seems to me that if you read his 300-plus opinions, what his opinions reveal to me is a dissatisfaction. I think he would argue a constitutionally compelled dissatisfaction with power-hungry executive branch bureaucrats doing our job when we fail to do it. And in this view, I think he's aligned with the founders. For our Constitution places power not in the hands of this city's bureaucracy, which can't be fired, but our Constitution places the policy-making power in the 535 of our hands because the voters can hire and fire us. And if the voters are going to retain their power, they need a legislature that's responsive to politics, not a judiciary that's responsive to politics. It seems to me that Judge Kavanaugh is ready to do his job. The question for us is whether we're ready to do our job. Thank you, Mr. Chairman.
Yeah. The example I always use to back up what Senator Sass says about Congress not doing its job and delegating too much is the Obamacare legislation that was 2,700 pages, and there was 1,693 delegations of authority to bureaucrats to write regulations because Congress didn't know how to reorganize health care. Senator Coons.
Thank you, Mr. Chairman. Welcome, Judge Kavanaugh. Welcome to you and to your family and to your friends who are here. As you know well, we went to the same law school. We clerked in the same courthouse in Wilmington, Delaware. So I've known you and your reputation for nearly 30 years. And I know well that you have a reputation as a good friend, a good classmate, a good roommate, as a good husband and family man, that you've contributed to your community. I think we'll hear later today that you've even been a great youth basketball coach. But frankly, we're not here to consider you as the president of our neighborhood civic association or even to review whether you've been a great youth basketball coach. We're here to consider you for a lifetime appointment to the United States Supreme Court, where you will help shape the future of this country and have an impact on the lives of millions of Americans for literally decades to come. And to make that decision to exercise our constitutional role, we have to look closely at your decisions, your statements, your writings to understand how you might interpret our Constitution. The next justice will play a pivotal role in defining a wide range of critical issues, including the scope of the president's power and determining whether the president might be above the law. The next justice will impact essential rights enshrined in our modern understanding of the Constitution, including the right to privacy, rights to contraception, intimacy, abortion, marriage, the freedom to worship as we choose, the ability to participate in our democracy as full citizens, and the promise of equal protection. That's because the cases that come before the court aren't just academic or esoteric or theoretical. They involve real people and have real and lasting consequences. With the stakes this high, I deeply regret the process that's gotten us to this point, the excesses and partisan gamesmanship of the last few years, and that history bears briefly repeating. When Justice Scalia passed in February of 2016, I called the White House and urged then President Obama to nominate a jurist who could gain support from both sides of the aisle and help build a strong center on the court. And he did just that when he nominated Merrick Garland, Chief Judge of the D.C. Circuit, whom I know you also admire. But my Republican colleagues refused to even meet with him, much less hold a hearing or a vote on his confirmation. During the 400 days that the majority refused to fill the Supreme Court vacancy, then President Trump also released a list of potential nominees to the court, a list compiled by two highly partisan organizations, the Federalist Society and the Heritage Foundation. And after our president was elected, he picked from that list and nominated Neil Gorsuch to the Supreme Court. When Judge Gorsuch testified before this very committee, he told us repeatedly how deeply he understood and respected precedent. He even cited a book on precedent he'd co-authored with you. But in his first 15 months of service, Justice Gorsuch has already voted to overrule at least 5 important Supreme Court precedents and to question many others. To name just one, given it was just Labor Day, Justice Gorsuch voted to gut public sector unions, overturning a 41-year-old precedent on which there were great reliance interests in impacting millions of workers across the country. My point is that Justice Gorsuch was confirmed to the court in one of the most concerningly partisan processes in Senate history, and only after the majority deployed the nuclear option to end the filibuster for Supreme Court nominations. This brings us, Judge, to today and your nomination. When Justice Kennedy announced his retirement, I once again called the White House and urged through White House counsel that President Trump consider selecting someone for the seat who could win broad support from both sides of the aisle. And Judge Kavanaugh, I'm concerned you may not be that nominee. Your record prior to joining the bench places you in the midst of some of the most pitched and partisan battles in our lifetimes, from Ken Starr's investigation of President Clinton to the 2000 election recount to the controversies of the Bush administration, including surveillance, torture, access to justice, and the culture wars. So, Judge, it's critical that this committee and the American people fully examine your record to understand what kind of justice you would be. And unfortunately, as we've all discussed at length here today, that's been rendered impossible. The majority has blocked access to millions of pages of documents from your service in a critical role in the White House. For the first time since Watergate, the nonpartisan National Archives has been cut out of the process for reviewing and producing your records. Senate Republicans have worked to keep committee confidential nearly 200,000 pages of documents so that the public can't view them and we can't question based on them. And your former deputies in charge of designating which documents this committee and the American people get to see. Not only that, but for the first time in our history, the President has invoked executive privilege to withhold more than 100,000 pages of documents on a Supreme Court nominee from the Judiciary Committee. This leads to a difficult but important question, which is what might President Trump or the majority be trying to hide? Mr. Chairman, I want to make an appeal to work together to restore the integrity of this committee. We are better than this process. We are better than proceeding with a nominee without engaging in a full and a transparent process. This committee is failing the American people by proceeding in this way, and I fully support the motions made by my colleagues earlier in this hearing and regret that we proceeded without observing the rules of this committee. That said, Judge Kavanaugh, I have reviewed the parts of your record that I've been able to access and what I've been able to see from available speeches, writings, and decisions, and I have to say it troubles me. While serving on the bench, you've dissented at a higher rate than any circuit judge elevated to the Supreme Court since 1980, and that includes Judge Bork. Your dissents reveal some views and positions that fall well outside the mainstream of legal thought. You've suggested, as has been referenced, that the President has the authority to refuse to enforce a law such as the Affordable Care Act were he to decide it was unconstitutional. You voted to strike down net neutrality rules, gun safety laws, the organization of the Consumer Financial Protection Bureau, and many of your dissents would undercut environmental protections or workers' rights or anti-discrimination laws. And you've recently praised Justice Rehnquist's dissent in Roe. You've embraced an approach to substantive due process that would undermine the rights and protections of millions of Americans, from basic protections for LGBT Americans to access to contraception, to health care, and the ability for Americans to love and marry whom they wish. I'm concerned your writings demonstrate a hostility to affirmative action and civil rights. And most importantly, I believe you've repeatedly and enthusiastically embraced an interpretation of presidential power so expansive it could result in a dangerously unaccountable president at the very time when we are most in need of checks and balances. I want to pause for a moment on this last point because the context of your nomination troubles me the most. In reviewing your records, Judge, you've questioned the lawfulness of United States v. Nixon, an historic decision in which a unanimous court said the president had to comply with a grand jury subpoena. You've questioned the correctness of Morrison v. Olson, a 30-year-old precedent holding that Congress can create an independent counsel with the authority to investigate the president, who the president can't just fire on a whim. You've questioned whether a president and his aides should be subject to any civil or criminal investigations while in office. And given these positions about presidential power, which I view as being at one extreme of the record of circuit judges, we have to confront an uncomfortable but important question about whether President Trump may have selected you, Judge Kavanaugh, with an eye towards protecting himself. So, Judge Kavanaugh, I'm going to ask you about these issues as I did when we met in my office, and I expect you to address them. When we spoke, you agreed that we have a shared concern about the legitimacy of the Supreme Court, that it is critical to our system of rule of law. In my view, it is today in jeopardy. You're participating in a process that has featured unprecedented concealment and partisanship around your record. And a few moments ago, Senator Durbin proposed a bold step, which would be for you to support, suspending this hearing until all your records are produced and available to this committee and the American people, and I encourage you to do this. There's also members of both parties who have not stated how they will vote on your nomination, and I urge you to answer our questions about your prior work, about your writings, about precedent and the Constitution itself, to trust the American people and to help build our trust in the court on which you may well soon serve. I've been to too many hearings in which judicial nominees have told us they'll even-handedly apply the text of laws or the Constitution only to watch them ascend to the bench and whittle away individual rights of Americans or narrow or overturn long-settled precedent. This Supreme Court vacancy comes at a critical time for our country, when our institutions of law and the very foundations of our democracy are being gravely tested. If we're going to safeguard the rule of law in this country, our courts, and in particular our Supreme Court, must be a bulwark against unprecedented violations of law, deprivations of freedom, and abuses of power by anyone, including our president. No one said it better than our former colleague, Senator McCain, who once asked about America, what makes us exceptional? Is it our wealth, our natural resources, our military power, our big and bountiful country? No, it's our founding ideals and our fidelity to them and our conduct in the world. They are the source of our wealth and power, that we live under the rule of law. That enables us to face threats with confidence that our values make us stronger than our enemies. Judge Kavanaugh, we're here to determine whether you would uphold or undermine those founding ideals and the rule of law. We're here to determine whether you would continue in the traditions of the court or transform it into a body more conservative than a majority of Americans. We're here to determine whether your confirmation would compromise or undermine the legitimacy of the court itself. I urge you to answer our questions and to confront these significant challenges. These are weighty questions, and the American people deserve real answers. Thank you, and I look forward to your testimony.
Yeah, you can easily get the impression, not just from Senator Coons, but other senators, that somehow you, Judge Kavanaugh, are out of the mainstream some way. So I looked at your record in the D.C. Circuit and have found that judges have agreed with you and your rulings in an overwhelming majority of matters across the board. 94% of the matters Judge Kavanaugh heard were decided unanimously. In 97% of the matters Judge Kavanaugh heard, he voted with the majority. Judge Kavanaugh issued dissenting opinions in only 2 7/10% of the matters that you heard. I would also like to clarify what the Presidential Records Act requires. Our documents process has fully complied with the Presidential Records Act. Under the federal statute, President Bush has the right to request his own administration records. He also has the authority to review his records before the Senate receives them. Indeed, the archives may not produce them to the committee without giving President Bush and his statutory representatives an opportunity to review first. This is what President Bush has done, and the National Archives does not have the authority to second-guess President Bush's decision to release records to us. The National Archives was not cut out of the process. As President Bush's representative informed the committee, quote, because we have sought, received, and followed NARA, that means the archivist's views on any documents withheld as personal documents, the resulting productions of documents to the committee is essentially the same as if the archivist had conducted its review first and then sought our views and the current administration views as required by law, end of quote. Senator Flake.
Thank you, Mr. Chairman. Congratulations, Judge Kavanaugh, and congratulations to your family as well. Let me just say a few things about the issue that has been discussed here a lot today, the issue of documents and document production. The standard historically that we use to looking at nominees is what is relevant and probative. I would suggest that we certainly get that from the 12 years you've served on the circuit court, on the DC Circuit Court, that considers, when you look at the docket, items that, more than any other circuit court, that the Supreme Court would be perhaps called to rule on. In the past, senators on this panel have argued on both sides of the aisle that confirming a judge, the best we can look at is his or her judicial record. You have that record, and it's a long one, over 300 opinions, and I would suggest that that's where we need to start. A lot of the other records that have been discussed are mainly duplicative, administrative documents. Many do not meet the standard of relevant or probative. They may not demonstrate the type of justice that you will be. Senator Sass talked about what we are called to do here, is to look at your temperament, your judgment, and your character. And I think you can see a lot of that by the type of life you've lived outside of the courtroom. When we met in my office, I was impressed, obviously, with your respect for the law and quick intellect, but also struck by kindness and decency. I found out that we share deep love of sports. We both played football back in the day. I'm sure you're looking forward to this weekend, not just when these hearings are concluded, but when the Redskins and Cardinals play on Sunday. I learned that you've run the Boston Marathon twice. I wonder if the ABA took that into account when they gave you a favorable rating. I'm not sure what that says about your soundness of mind myself. But in all seriousness, training for a marathon, completing 2 marathons like this is a huge accomplishment. It demonstrates not just your competitive spirit, but a strong sense of purpose and commitment, and says something about your temperament and character. Of course, you have no greater commitment than to your family, your wife Ashley, and your 2 daughters. I know that you beamed with pride when talking about them, and talking about, as has been mentioned earlier, coaching your daughter's elementary school basketball teams. I have a letter for the record written by a group of parents whose girls play for basketball teams that Judge Kavanaugh coaches. And with Mr. Chairman, without objection, I'd like to enter that letter into the record.
So ordered.
The team's parents note that Judge Kavanaugh has been a devoted coach and a mentor to their daughters. As these parents note, Coach K, and that's you, not the Duke famous one, stresses the importance of playing as a team and has provided their girls the opportunity to learn about teamwork, honesty, integrity, humility, respect, discipline, hard work, and competitiveness. Again, we're going back to temperament and character. Judge Kavanaugh's dedication and commitment as a volunteer basketball coach, I think, demonstrates and says a good deal about that character. And congratulations to you and the Blessed Sacrament Bulldogs for winning the city championship this past year. I know you must be proud of your team. Now, aside from running marathons, winning basketball championships, you've spent, as I mentioned, the last 12 years as a federal appeals court judge on the DC Circuit. You have earned a reputation among legal commentators and colleagues on both sides of the aisle of a solid, careful judge, a thorough and clear writer, and someone who promotes collegiality on the court, working with people across ideological lines. I have also a New York Times article for the record written by Professor Akhil Amar, a self-professed liberal who describes Judge Kavanaugh as one who appreciates the craft of judging with seriousness and commands wide and deep respect among scholars, lawyers, and jurists across the political spectrum. Mr. Chairman, I'd like to submit that for the record as well.
Objection so ordered.
As I mentioned, Judge Kavanaugh has amassed an astonishingly distinguished and extensive record, writing more than 300 opinions, joining his colleagues in issuing thousands of additional cases. And that is where we need to look first when we're looking at how you will judge on the Supreme Court. Now, I know, and it has been brought up today, that a lot of the concern on the other side of the aisle stems from the concern of an administration that doesn't seem to understand and appreciate separation of powers and the rule of law. I have that concern as well. If you just look at what was said just yesterday by the president, I think it's very concerning. He said in a tweet, 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department, he calls it. 2 easy wins now in doubt because there is not enough time. Good job, Jeff. That is why a lot of people are concerned about this administration and why they want to ensure that our institutions hold. Thus far they have, gratefully. Jeff Sessions has resisted pressure from the president to punish his enemies and relieve pressure on his friends. And many of the questions that you will get on the other side of the aisle and from me will be how you view that relationship, where you believe the Article 1 powers and Article 2 powers of the administration begin. So I expect to have a number of questions on that subject. I, again, appreciate your willingness to put yourself through this process, and I look forward to the hearing moving ahead in the next week. Thank you, Mr. Chairman.
Okay. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, for your conducting these hearings as fairly and patiently as you have. And I am going to be remarking further on what procedurally I think is appropriate here. But I want to begin by thanking Judge Kavanaugh and your family for your commitment to public service. I want to thank the many, many Americans who are paying attention to this hearing, not only in this room, but also across the country. I want to thank them for their interest and indeed their passion. That is what sustains democracy, that commitment to ordinary, everyday Americans participating and engaging in this process. There is a T-shirt worn by a number of folks walking around this building that says, "I am what's at stake." This vote and this proceeding could not be more consequential in light of what is at stake, whether women can decide when they want to have children and become pregnant, whether the people of America can decide whom they would like to marry, whether we drink clean water and breathe clean air, whether consumers are protected against defective product and financial abuses, and whether we have a real system of checks and balances or, alternatively, an imperial presidency. I will not cast a vote more important than this one, and I suspect few of my colleagues will as well. And what's at stake is indeed also the rule of law. My colleague, Senator Flake, quoted the president's tweet yesterday. I'm going to repeat it. 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department. 2 easy wins, now in doubt because there is not enough time. Good job, Jeff. I've had my disagreements with this Department of Justice. I want to note for the record that at least one high-ranking member of the Department of Justice was in this room. I want to urge the Department of Justice to stand strong and hold fast against this onslaught, which threatens the basic principles of our democracy. And I want to join my colleague, Senator Sass, in his hope that you, Judge Kavanaugh, would condemn this attack on the rule of law and our judiciary. Because at the end of this dark era, when the history of this time is written, I believe that the heroes will be our independent judiciary and our free press. You are nominated by that very president who has launched this attack on our Department of Justice, on the rule of law, on law enforcement, like the FBI, law enforcement at every level, whose integrity he has questioned. And your responses to our questions will be highly enlightening about whether you join us in defending the judiciary and the rule of law. That very president has nominated you in this unprecedented time, unprecedented because he is an unindicted co-conspirator who has nominated a potential justice who will cast the swing vote on issues relating to his possible criminal culpability. In fact, whether he is required to obey a subpoena to appear before a grand jury, whether he is required to testify in a prosecution of his friends or associates or other officials in his administration, and whether, in fact, he is required to stand trial if he is indicted while he is President of the United States. There is a basic principle of our Constitution, and it was articulated by the founders. No one can select a judge in his own case. That's what the president's potentially doing here, selecting a justice on the Supreme Court who potentially will cast a decisive vote in his own case. That is a reason why this proceeding is so consequential. Senator Sass urged us to do our job. I agree. Part of our job is to review the record of the nominee as thoroughly and deliberately as possible, looking to all the relevant and probative evidence. We can't do that on this record. Mr. Chairman, you have said multiple times that your staff has already reviewed the 42,000 pages of documents produced to this committee at 5:41 p.m. yesterday. Both sides are using the same computer platform to review the documents from Mr. Burke. The documents had to be loaded into this platform overnight and couldn't be concluded until 6:45 a.m. this morning. How is it possible that your staff concluded its review last night before the documents were even uploaded? That's this platform that both sides are using here. Simply not possible, Mr. Chairman, that any senator has seen these new materials, much less all of the other relevant documents that have been screened by Bill Burke, who is not the National Archivist. And this situation, when we say it's unprecedented, is truly without parallel in our history. And I'm going to quote from the National Archivist. It's, quote, something that has never happened before, And the archivist continued, this effort by former President Bush does not represent the National Archives or the George W. Bush Presidential Library, end quote. So, Mr. Chairman, I renew my motion to adjourn so that we have time to conclude our review of these documents, and so that also my request under the Freedom of Information Act, which is now pending, to the National Archivist, to the Department of Justice, to other relevant agencies, can be considered and judged. That Freedom of Information Act will require some time, I assume, to conclude. I renew my motion, Mr. Chairman, and ask for a vote on the motion to adjourn. As I said earlier, Rule 4 provides, quote, the committee chairman shall, not may, shall entertain a non-debatable motion to bring a matter before the committee to a vote. That seems pretty clear to me, Mr. Chairman. I've made a motion to bring before the committee a motion to adjourn under the rules. With all due respect, you are required to entertain my motion. And I would just add this final point. All of these documents will come out. They will come out eventually, as soon as 2019 and 2020. By law, these documents belong to the American people. They don't belong to President Bush or President Trump. They belong to the American people. It's only a matter of time, my Republican colleagues, before you will have to answer for what's in these documents. We don't know what's in them, but the question is, what are they concealing that you will have to answer to history for? Mr. Chairman, I renew my motion to adjourn.
You quote the rules very accurately, but those rules apply to executive business session. We're not in an executive business session, so I deny your
Mr.
motion.
Chairman, with all due respect, I ask you to point to me the language in Rule 4 or anywhere else in our rules that limits its scope to executive business meetings. There is no such language, Mr. Chairman.
I would have you quote language to the contrary.
Could you quote me that language?
No, I'm asking you. You quote me a language to the contrary of what I ruled.
There is no language to the contrary. I'm asking for a vote in this session now. There's nothing that precludes the vote in our hearing at this exact time.
Okay, I've ruled. You want to proceed, do you?
Well, if the chair, with all due respect, is ruling against me, I move to appeal the ruling of the chair. With all due respect, the chairman is not above the rules of the committee. I ask for a roll call vote to overturn the ruling of the chair and to allow for a vote on my motion to adjourn these proceedings.
That would be an appropriate motion if we were in executive business session, but we're not in executive business session, so it's denied.
Mr. Chairman, I will proceed under protest. We've had a lot of rhetoric so far about rules and norms. I am very regretful that the chair has adopted this stance, which in my view contradicts our basic norms and rules. But I will proceed. Mr. Chairman, I have fears about what this nominee will do with respect to our rule of law, but also about basic rights that have been established by past Supreme Court precedent. And the only way to test what his fidelity to the rule of law is, in fact, is to ask, as I have asked every judicial nominee coming before me when I have served on this committee in hearings, whether he believes past decisions of the Supreme Court were correctly decided. So I'm going to be asking you, Judge Kavanaugh, whether you believe Roe v. Wade was correctly decided.
Mr.
I'm
Chairman,
going to be asking you,
Mr. Chairman, may I ask a question? I was under the impression each of us had 10 minutes for an opening statement. We'll have 50 minutes for questions, but.
Let me clarify.
And then, plus I would
Well,
ask,
I
Mr.
don't-
Chairman,
I
the
ask
various
that
members have been making speeches all day long and have not been confined to their 10-minute opening statement.
Okay. Well, like I told you,
I think I have time left on my 10 minutes.
you will have time. I'm going to let you finish. Just
Thank
a
you.
minute. I was hoping that the 10-minute rule would stand, but we got off to a very bad start. And we got off to a bad start, and everybody started exceeding their time limit. So I guess as long as we have to stay here and get this all done today. If we have to stay into the night, we're going to stay, but I'm not going to cut anybody off now that I didn't do it right away. And like you said, mob rule, I've always said to myself when advising other people, either you run the committee or the committee runs you. And I let the committee run me this time. So let's just proceed as we have and let Senator Blumenthal take what time he wants. I hope you won't go too long.
I'll be very judicious.
Thank you.
Mr. Chairman. Thank you.
I don't know what that means.
Yeah, I don't know. He's not answering.
I'm sorry, Senator Corner, and I can't agree with you. We just proceed. Senator Blumenthal.
Thank you, Mr. Chairman.
Next time, Mr. Chairman.
So I will be asking Judge Kavanaugh whether you believe Roe v. Wade was correctly decided, whether you believe Brown versus Board of Education was correctly decided. Judicial nominees have figured out all kinds of ways to avoid answering that question. First, they said they felt it would violate the canons of ethics. There are no canons of ethics that preclude a response. Then they said that they felt a decision might come before them, an issue in a case that might arise. And more recently, they've adopted the mantra that they think all Supreme Court decisions are correctly decided. But you're in a different position. You've been nominated to the highest court in the land, and your decisions as a potential swing vote could overturn even well-settled precedent. And there are indications in your writings, your opinions, as well as the articles you've written and some of the memos that have come to light that you believe, for example, Roe v. Wade could be overturned. And that's why I want to know from you whether you think it was correctly decided in the first place and other decisions that are regarded as well settled or long established. In fact, I have these fears because Judge Kavanaugh, this system and process has changed so radically. In fact, you have spent decades showing us in many ways what you believe. Or to put it more precisely, you've spent decades showing those groups like the Federalist Society and the Heritage Foundation and others what you believe. They're the ones who have really nominated you because the president outsourced this decision to them. In those opinions and writings and statements and interviews, you've done everything in your power to show those far-right groups that you will be a loyal soldier on the court. And I'm going to use some of those writings and some of the timing and other indications to show that you are more than a nominee, in fact, a candidate in a campaign that you have conducted. That seems to be, unfortunately, the way the system has worked in your case. The norms have been dumbed down and the system has been degraded, but I think that we have an obligation to do our job and elicit from you where you will go as a justice on the United States Supreme Court based on what you've written and said and also what you will tell the American people in these hearings. I join in the request that's been made of you, that you show the initiative and ask for a postponement on these hearings. I think that this process has been a grave disservice to you, as well as this committee and the American people. If you are confirmed after this truncated and concealed process, there will always be a taint. There will always be an asterisk after your name, appointed by a president, named as an unindicted co-conspirator, after the vast majority of documents relating to the most instructive period of his life were concealed. The question will always be, why was all that material concealed? You've coached and you've mentored judges in going through this process. You are as sophisticated and knowledgeable as anyone who will ever come before us as a judicial nominee. So you know that we have an obligation to inquire as to everything that can be relevant. And it's not the numbers of documents. It's the percentage. There were no emails when Justice Ginsburg was the nominee. The documents that we've been provided contain duplicates. They're full of junk. We need everything that is relevant, including the 3 years that you served in the Bush White House as staff secretary, the most instructive period of your professional career. So let me just conclude by saying, what we share, I think, is a deep respect and reverence for the United States Supreme Court. I was a law clerk, as you were. I've argued cases before the court. Most of my life has been spent in the courtroom as U.S. Attorney or as Attorney General. The power of the Supreme Court depends not on armies or police force, it has none, but on its credibility, the trust and confidence of the American people. I ask you to help us uphold that trust by asking this committee to suspend this hearing and come back when we have a full picture with the full sunlight that our chairman is so fond of espousing, so that we can fully and fairly evaluate your nomination. Thank you, Mr. Chairman.
Once again, I would remind everybody we have half a million documents on this gentleman's record. And also, I'd like to respond to the fact that you can't go 42,000 pages, which I guess is way over the number of documents that we actually received. The majority and minority received documents in two ways. One is a format that can be uploaded to reviewing platforms, and the second is in a standard document file format called PDFs. Given the importance of reviewing documents in a timely manner, my staff reviewed the PDF versions. The production was relatively small, and therefore there was no need to upload them to a reviewing Senator Kennedy. Senator Kennedy, you're next. You're next, Senator Kennedy.
Thank you, Mr. Chairman. I've listened with interest today. I agree so much with what Senator Sass said. I listened today, and it's no wonder to me that so many Americans think that the United States Supreme Court is nothing more than a little Congress. a political body like the United States Senate. Let me try to explain what I'm looking for in a Supreme Court justice. I want a judge. I don't want a politician. Now, I'm not naive. It's true, Senator Booker and I are new to the Senate. We didn't come here when Moses walked the earth. But we're not new to politics. And I understand that human relations are about politics. I get that. But I don't think our founders ever intended for the United States Supreme Court to become a political body. I don't. I'm not looking for an ideologue. I'm not looking for a hater. What I am looking for is somebody who is whip smart, who's intellectually curious, who writes cleanly and crisply, who knows what a semicolon is for, and who is willing to protect the United States Constitution and the Bill of Rights and understands that the Bill of Rights is not an a la carte menu. Every one of them counts. Let me try to explain further why I agree with so much of what Senator Sass said. This is not a news flash. Our country is divided. We've been divided before. We'll be divided again. We will survive this. But I confess the division in our country today seems to me to be especially sharp. And what concerns me so much about that division is the basis for it. It's not honest disagreement. So much of it is anger. There have been thousands, millions of pages written about the genesis of that anger. We all have opinions. You know what they say about opinions. Here's mine. I think a big part of the anger in America today is because we have too many Americans who aren't sharing in the great wealth of this country. Not economically, not socially, not culturally, and not spiritually. And those Americans believe that the American dream has become the American game and that game is fixed. Let me give you one example why I say that. I don't hear it so much today. I'm biased, but I happen to think the Tax Cuts and Jobs Bill Act worked. But when I ran 2 years ago, I would hear it every single day. People would stop me and they would say, Kennedy, you know what's wrong with us economically? They would tell me, I look around, Kennedy, and I see too many undeserving people. I emphasize undeserving. I don't want to paint with too broad a brush. They would tell me, Kennedy, I look around and I see too many undeserving people at the top getting bailouts. And I see too many undeserving people at the bottom getting handouts. And I'm here just a working smuck in the middle, stuck in the middle, and I can't pay the freight anymore because my health insurance has gone up and my kids' tuition has gone up and my taxes have gone up, but I tell you what hadn't gone up, my income. Now, I happen to think we're doing better in that regard, but we've still got to work a long way to go. But here's the point. Who's supposed to fix that for the American people? It's us. It's the United States Congress. It's not the United States Supreme Court that's supposed to fix this country culturally, economically, socially, spiritually. And that's why I say I agree with so much of what Senator Sass said. It's almost become cliche, but the role of a judge is, or at least should be, to say what the law is, not what the law ought to be. Now, it's become cliche, but cliches become cliches because they're true. Judges are not put there to try to bypass the ballot. Courts should not try to fix problems that are within the province of the United States Congress, even if the United States Congress doesn't have the courage to address those problems. Our courts were not meant to decide these kind of issues. I'm not naive. I know that judges aren't robots. We can't replace you and shouldn't try to replace you with a software program based on artificial intelligence. You have discretion. We're going to talk about that if we ever get to the questioning part of this exercise. But I want to say it again. I understand why, listening today, that so many Americans believe that the law, which I think all of us revere, has become politics just pursued in another way. It's not the way it's supposed to be, Judge. That's not what I'm looking for. Now, I'm going to end. I still got plenty of time left. I think I have 2 hours allotted, Mr. Chairman. Somebody talked about, said they'd seen this movie before. I commented to my friend Senator Tillis, this thing's as long as a movie. These are the words of Justice Curtis. In 1857, when he dissented in the Dred Scott case. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We're under the government of individual men who for the time being have power to declare what the Constitution is, according to their own views of what it ought to mean. That's not the rule of law. Justice Scalia put it another way, and I truly will end with that. He said the American people love democracy, and the American people are not fools. The people know their value judgments are quite as good as those taught in any law school, maybe better. Value judgments, after all, should be voted on, not dictated. And that's what I'm looking for, Judge. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Judge Kavanaugh and your family, welcome. Mr. Chairman, earlier on today, I pointed to an op-ed that had been written by two former White House staff secretaries, John Podesta and Todd Stern, entitled, "Staff Secretaries Aren't Traffic Cops. Stop Treating Kavanaugh Like He Was One." And I note in their op-ed what they said. I will quote part of it. That they said that when they handled the job for President Bill Clinton in much the same way that staff secretaries did for President George H.W. Bush, we wrote concise cover memos for every decision memo that went to the president. We summarized the underlying memo, identified the core decision points and options, and conveyed the views of key senior staff members from whom we had sought comment. We wrote hundreds of these memos. It is no wonder that Judge Kavanaugh has deemed his time as White House staff secretary so important to his performance as a judge. But unfortunately, as we have said many times already, we don't have any of these documents during Judge Kavanaugh's time as staff secretary. Dana Sabraw, Michael Bilson, Ketanji Brown Jackson, Colleen Kolar Cotelli, Naomi Reese Buchwald, John Bates, Derek Gahala Watson. These are the names of some of the federal judges across this country who have vindicated my faith in the rule of law over the last year and a half. These are the women and men appointed by Republican and Democratic presidents who ordered the government to reunite parents with their children ripped from their arms at the border, who rejected attempts to deny federal funds to cities refusing to be drawn into the war against immigrants, who stopped executive orders aimed at kneecapping public sector unions, who stopped the implementation of an ugly ban on transgender Americans serving in our military, who ruled that public officials cannot block citizens from their Twitter feeds, and who stopped the government from banning Muslims from entering the United States. These judges stood firm in defense of the Constitution, the American values it expresses, and the system of checks and balances it enshrines. At this moment of peril for our democracy, it is these judges and others like them who have pushed back against the efforts of a president eager to wield unlimited and unchecked power. In normal times, we will be here today to determine the fitness of a nominee to the Supreme Court of the United States chosen for his or her legal talent and reputation for fairness. But these are not normal times. Instead, we are here to decide whether or not to rubber stamp Donald Trump's choice of a pre-selected political ideologue nominated precisely because he believes a sitting president should be shielded from civil lawsuits, criminal investigation, and prosecution, no matter the facts. Let's not forget, during his campaign, Donald Trump needed to shore up his support from the Republican base, who questioned whether he was sufficiently conservative. To help, he turned to the Federalist Society and the Heritage Foundation to build a pre-approved list of names and promised to pick from among them when selecting nominees for the Supreme Court. These groups are long-standing right-wing organizations that advocate for conservative causes and legal positions. The Heritage Foundation focuses on developing policy to, among other things, oppose climate change, repeal the Affordable Care Act, and reduce regulations for big businesses. The Federalist Society focuses on changing the American legal system to align with an ultra-conservative interpretation of the Constitution, including the overturning of Roe v. Wade. When given the opportunity to nominate a new Supreme Court justice, Donald Trump did exactly as he promised. He did not select someone who demonstrates independence and fidelity to the rule of law. Instead, Donald Trump selected a pre-approved name in order to guarantee a fifth vote for his dangerous anti-worker, anti-consumer, anti-women, pro-corporate, and anti-environmental agenda. And Donald Trump selected Brett Kavanaugh from this list for an even more specific reason. The president is trying as hard as he can to protect himself from the independent, impartial, and dogged investigation of his abuse of power before the walls close in on him entirely. Because if there's one thing we know about Donald Trump, it is that he is committed to self-preservation every minute, every hour, every day. Judge Kavanaugh's appointment should be considered in a broader context. The president has been packing our courts with ideologically driven judges who come to the bench with firm positions and clear agendas, who then go on to rule in ways consistent with those agendas. For example, Trump nominee James Ho, now a judge on the Fifth Circuit, has written in favor of unlimited campaign contributions and, in another case, publicly aired his personal views in opposition to abortion. Trump nominee Don Willett, now a judge on the Fifth Circuit, has already voted to curtail the independence of a federal agency that helped rescue the economy after the mortgage crisis of 2008. Trump nominee Stephen Bibos, now a judge on the Third Circuit, wrote a dissent to explain that he does not believe Title IX requires school districts to provide transgender students appropriate changing facilities and bathrooms. Trump nominee Amy Coney Barrett, now a judge on the Seventh Circuit, ruled to keep out-of-court employees trying to challenge an arbitration proceeding and cast the deciding vote to allow a business to continue to segregate its workforce. And Trump nominee John K. Bush, now a judge on the Sixth Circuit, ruled to keep out of court a woman accusing her employer of age discrimination, despite a dissenting judge's view that there was sufficient evidence to go forward. When these Trump-nominated judges came before this Judiciary Committee as nominees, my Democratic colleagues and I tried to find out how they would go about deciding tough cases what they would base their decisions on when the law did not give a clear enough direction, as is often the case. And time and again, we were told, don't worry about my personal background or my history as a partisan political advocate. Don't worry about what I've done, written, or said until now. When I get on the bench, I'll just follow the law. But clearly, they have not. Why should we expect this Supreme Court nominee, you, to be any different? President Trump selected Brett Kavanaugh because of his fealty to the partisan political movement he has been a part of his entire professional life. From his clerkship with Judge Alex Kozinski, to his apprenticeship with Ken Starr, to his work on George W. Bush's legal team during the Florida recount and in the White House, Judge Kavanaugh has been knee-deep in partisan politics. The first reward for that service was his nomination to the D.C. Circuit. It was a tough fight, but Republican-aligned special interests fought for more than 3 years to get him confirmed. And for the past 12 years as a judge, he has ruled, whether in dissent or majority, in ways in line with their political and ideological agenda. Now, President Trump has selected Judge Kavanaugh to provide the decisive fifth vote in cases that will change some of the most basic assumptions Americans have about their lives and their government. There are more than 730 federal judges working on thousands of cases across the country every day, and most of these cases end in trial courts. Some of them are appealed and heard in appellate courts. The closely divided Supreme Court hears very few cases, many times fewer than 100 every year. Before Justice Kennedy retired, so many important constitutional rights were hanging in the balance, decided on narrow grounds by 5-4 votes. And now that Justice Kennedy has left the court, the forces opposed to workers' rights, women's rights, LGBTQ rights, voting rights, civil rights of all kinds, and environmental protections are eager to secure a solid majority on the court to support their right-wing views. These ultra-right-wing forces have been working for decades to prepare for this moment because they know that a single vote from one justice is all it would take to radically change the direction of this country. It could take just one vote on the Supreme Court to overturn Roe v. Wade and deny women control over their reproductive rights. It could take just one vote to declare the ACA's pre-existing condition protections unconstitutional. It could take just one vote to dismantle environmental protections that keep our air safe to breathe and our water clean to drink. It could take just one vote to dismantle common sense gun safety laws that keep our communities safe. And it could take just one vote to further erode protections for working people and unions. Since this nomination was announced, I have been asked many times why the Democrats would even bother to go through the motions when we know that our Republican colleagues will do anything to support this administration's judicial nominees. There are battles worth fighting, regardless of the outcome. A lifetime appointment to the Supreme Court of someone who will provide the fifth vote on issues impacting the lives of every working American is a battle worth fighting. So I intend to use this hearing to demonstrate to the American people precisely why who sits on the Supreme Court matters, why a fifth ideologically driven conservative and political vote on the court is dangerous for our country, why the Senate should reject this president's latest attempt to rig the system in his favor. As senators begin to ask their questions in the coming days, I ask the American people to listen carefully to what the nominee says and compare it with what we heard only a short time ago from Neil Gorsuch at his confirmation hearing. Just 18 months ago, Judge Gorsuch told us that, quote, all precedent of the United States Supreme Court deserves the respect of precedent, which is quite a lot. It's the anchor of the law. Judge Gorsuch said, it's not whether I agree or disagree with any particular precedent. That would be an act of hubris. Because a precedent, once it's decided, it carries far more weight than what I personally think, he said. Judge Gorsuch made these promises when he was asking for our votes. But earlier this year, he joined a majority of the court to overturn precedent in a 41-year-old case that protected government workers and their ability to form a union in a 5-4 decision. I expect Judge Kavanaugh to make similar promises over the next few days, only to do, sadly, the exact opposite if confirmed. Our job here is important because every American should be concerned about what our government and country would look like if Judge Kavanaugh is confirmed. We owe it to the American people and to all of the independent-minded judges I mentioned at the beginning of my remarks to preserve the integrity of our Constitution and the fairness and order of a system that has served us well for so long. Judge Kavanaugh, what may be going through your mind right now is to simply and stoically endure this hearing. But don't you think you owe it to the American people to disclose all of the documents being requested because you have nothing to hide, because you have nothing to hide? I agree with my colleague, Senator Durbin, Judge Kavanaugh. If you stand behind your full record in public life, fundamental fairness would dictate that you join us in our call for this committee to suspend until we receive all relevant documents and have a chance to review them. Your failure to do so would reflect a fundamental mistrust of the American people. Thank you, Mr. Chairman, and I would like to have entered into the record the op-ed piece that I referred to by John Podesta and Todd Stern.
Without objection, it will be entered. Let's go to Senator Crapo's next.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome. Thank you for your service to this country, and thank you for the willingness you have expressed to take this additional assignment. And thank you to your family. We welcome them as well. The process on which we're about to embark is one of maybe not the most important duties entrusted to the Senate: advice and consent on judicial nominations. Ultimately, a fair and proper judge, Supreme Court or otherwise, must follow the law and not make laws from the bench. Upon receiving his nomination to serve as an Associate Justice of the Supreme Court, Judge Kavanaugh stated, "My judicial philosophy is straightforward. A judge must interpret statutes as written, and a judge must interpret the Constitution as written, informed by history and tradition and precedent." Isn't that the ideal of a judge steadfastly committed to the law? No one seriously questions Judge Kavanaugh's qualifications to serve as an Associate Justice on our nation's highest court. He is vastly experienced and widely respected for his intellect, his honesty, and his legal acumen. With over 300 authored opinions and 12 years of service on the bench, he is a judge with a clear record, demonstrating that he applies the law as written and enforces the Constitution. He values precedent and has written, along with Justice Gorsuch and others, The Law of Judicial Precedent, a scholarly piece on the importance of stare decisis. Sadly, much of the discourse surrounding Judge Kavanaugh's nomination deals not with the content of his legal opinions, his judicial philosophy, or temperament, but rather, as today's discussion has shown, the spurious notion that our distinguished chairman has not been rigorous or fair or transparent in navigating the requisite document production efforts required by this committee. Those claims are wholly without foundation. There have been 57 days since the announcement of Judge Kavanaugh's nomination on July 9 and today's confirmation hearing. This is a longer period of time than senators had for Justices Sotomayor, Kagan, and Gorsuch. Justice Kavanaugh also submitted over 17,000 pages with his bipartisan Judiciary Committee questionnaire, the most extensive questionnaire ever returned by a nominee to the Supreme Court. The committee also received more than 440,000 pages of documents related to his service in the executive branch. This, too, is more than any Supreme Court nominee to date. As has been said earlier, in fact, it's more than the last 5 nominees combined. I applaud Chairman Grassley and his dedicated staff for their tireless work in reviewing these documents and making the vast majority publicly available as quickly as possible. And frankly, Mr. Chairman, I believe the American people appreciate your efforts, your transparency, and your commitment to a fair process. Now, I want to make one side note. It was said here today that the number of documents provided by now Justice Kagan, who was also a nominee who had served in the White House and had many, many documents relating to her service. That 99% of the documents requested for her were provided. One problem with that fact, and that is that when Justice Kagan was before us, she had been the Solicitor General. There were probably more pages relevant to her service there than to your service. We don't know the number because the Republicans agreed, after a strong disagreement with the Democrats, that we wouldn't request those documents because the White House claimed they were sensitive. The Democrats have not made that agreement with the Republicans this time. But it's notable, I think it's incredibly important to note, that this argument that is going on today about the balance of document production is simply a trumped-up argument. These facts aside, many of my colleagues continue to criticize this process. Their motives are clear. Use any means available to attempt to delay the confirmation process of a well-qualified jurist fit for the job indefinitely. I strongly agree with the comments of many of my colleagues here today. Senator Cruz pointed out what was really at stake. Senator Sass pointed out why it is that Congress needs to be the part of our federal government that makes the law, not the judiciary. Senator Kennedy has followed up on that thought, as have many of my other colleagues here today. I think one point that Senator Cruz made deserves repeating. Much of what we are hearing today, and we'll hear for the remainder of this process, is ultimately an effort to relitigate the last presidential election. In fact, we have just heard Judge Kavanaugh attacked and stated to be unqualified because he is a Trump nominee. Other Trump nominees have also been attacked here today. The attack is on President Trump, not on their nominees, because of an unwillingness to accept the outcome of the last presidential election. Judge Kavanaugh, as the nominee, has been widely recognized for his judicial temperament and his detailed legal writings in defense of the Constitution. His opinions are widely cited by his fellow appellate judges and even the Supreme Court. And although his integrity was just challenged, stating that no matter what he says to this committee, he will vote the other way once put into office, put into the Supreme Court. The fact is that his record as the chairman has already outlined disproves that. He serves on the D.C. Circuit Court of Appeals, a court on which more of the judges who serve have been appointed by Democrat presidents than Republican presidents. Yet he has voted 97% of the time with his colleagues in the majority on that court, showing that he will follow the law and that he does so with the majority support of broad and, I was going to say bipartisan, but nonpartisan judges who are appointed by Republican and Democrat presidents and who consider some of the most important cases in America today. That is the judge we have before us. He's a judge's judge. Many critics argue that Justice Kavanaugh would play an instrumental role in reversing a number of Supreme Court precedents. However, I wonder how one can draw that conclusion given his record of exhaustive and weighty consideration of important legal questions on a court such as the D.C. Circuit. I recognize that it is politics driving these attacks, and so do the American people. They know what's at stake here. Moreover, in his legal opinions, Judge Kavanaugh has consistently demonstrated a willingness to rein in both Congress and the executive branch when they overstep their respective constitutional grounds. Judge Kavanaugh understands and is focused on the principle that a judge is a servant of the law, not the maker of it. We should take him at his own words. The judge's job is to interpret the law, not to make the law or policy. So read the words of the statute as written. Read the text of the Constitution as written, mindful of history and tradition. Don't make up new constitutional rights that are not in the text of the Constitution. Don't shy away from enforcing constitutional rights that are in the text of the Constitution. Those are Judge Kavanaugh's words. That is the man who sits before us, nominated to be a justice on the highest court of our land. Judge Kavanaugh has the backing of his former law clerks and law students, his colleagues on the bench appointed by both Republican and Democrat presidents, and many members of his local community in which he remains so closely involved. He is a man of honor, integrity, and well-respected in the legal community. There is no dispute he is qualified to serve on our nation's highest court. Mr. Chairman, I look forward to hearing from the nominee himself when we all get done with our statements. The next few days will prove insightful as we discuss with Judge Kavanaugh for the public to hear, in his own words, the proper role of a judge in our constitutional system. I look forward to this hearing. And again, Judge Kavanaugh, thank you for being willing to be here. Thank you, Mr. Chairman.
Thank you. Senator Booker.
Thank you, Mr. Chairman. Welcome, Judge Kavanaugh. And I want to say welcome to your family sincerely as well. We're all Americans and taking part in what is truly a historic moment. Mr. Chairman, Chairman Grassley, I hope you do not think earlier this morning that in any way I was questioning your integrity or your decency. I was appealing to it earlier before, and you have been conducting this hearing, giving myself and others the opportunity to at least speak and make our case. And even though you have not ruled in our favor, of which I'm disappointed, I do hope you understand that I value your friendship and frankly, some of the most valuable moments I've had in the Senate. I still remember shaking your floor and coming to agreement with you on criminal justice reform. I've come to have a deep respect for you, sir. So I hope you did not think I was doing that earlier.
If you worry about our friendship being affected, it will not be. And that gives me an opportunity to say something to the public at large. And that is about this committee. You would think that Republicans and Democrats don't talk to each other. But I'd like to remind the public that when they think that happens, they ought to think of the record of this committee, not just this chairman, but this committee in the 3.5 years, and maybe even before I got to be chairman, but in the 3.5 years I've been chairman, every bill that got out of this committee has been a bipartisan bill. Proceed, Senator Roker.
Thank you very much, sir. I appreciate that. It doesn't detract from the fact that I just fundamentally disagree with the way you've been concluding today. When I first got to the Senate, I was very fortunate that a lot of senior statesmen, yourself, Senator Hatch included, pulled me aside and gave me hard wisdom at times. Remember, I came to the Senate in a special election at a time that they were that we were changing some of the Senate rules. Senator Levin brought me aside and gave me a hard talking to. Senator McCain gave me a hard talking to. And all of them made similar points about this idea that sometimes you need to be as objective as possible and see how you would react if the pendulum was the other side swung the other way. In other words, they warned me that what goes around in this place comes around, and to really think that if the shoe was on the other foot. And I've been struggling with that, sir, with all honesty, of what would the Republicans be saying and what we would be saying if we had a Democratic president right now, a Democratic nominee right now, and this process was in the reverse. And I would like to believe how I would behave, and I'm pretty confident, I'd actually be a betting man, be willing to bet, that if the Republicans were being denied effectively about 90% of the documents about a person's public record, and I actually do believe that some of the analogies that are made to Justice Kagan and her Solicitor General time is not a fair analogy. This is a part of the nominee's history that he himself has said was one of the most formative times. And so I would not hire an intern in my office knowing only 90% of their resume. There's not a person here that would buy a home only seeing 90%, only seeing 10% of the rooms. I just believe what we're doing here, just on the objective view of fairness, is sincerely unfair, and it's insulting to the ideals that we try to achieve in this with some sense of comity and some sense of rules. But I want to go deeper than that. I'm trying to figure out what the jeopardy would be. What the jeopardy would be if we just waited for the documents. Last night we had a document dump of tens of thousands of pages. tens of thousands of pages. Has been said already, there's no judge that would allow a court proceeding to go on, no judge that would move forward if one of the parties had just got documents as of 5 o'clock last night or potentially as of 11 o'clock. What I don't understand is what's the jeopardy of just waiting, not just for us to digest these documents, but other documents. The reality is that Senator Grassley, you yourself have asked for a specific, more finite set, more limited set of documents that you haven't even gotten. And so whether it's not seeing 90% of the resume of the gentleman before us, or 50% or 40%, that should come within time. And there's no jeopardy when we have a lifetime appointment. He will be there, should he be confirmed, for decades and decades and decades. Waiting another week or 5 days or 2 weeks for those documents that you yourself has requested, which is a more limited subset, for even those documents to come through. I don't understand what the rush is, especially given all that is at stake. And so those are the reasons why I say to you with sincere respect that this is an absurd process. It just seems unfair to me, and it could easily be solved by us putting a pause here on this process, waiting for the documents, evaluating the documents, and it'll be a much more robust set of hearings on this nominee. As I said, I would not hire an intern if I only seen 10% of their resume. And here to have a fuller body of the work of this gentleman before us, who, as one of my colleagues called, popping up in some of the most interesting times in the last decade or two on some of the most important issues. Already the limited amount, what we call 7% of the documents that I've seen, unfortunately, those are things that are being held committee confidential, which I don't even know if I could use in my questioning here. I think the penalty, sir, is being ousted from the Senate. But even the little limited amount of documents have potentially made my questioning far more rich, far more substantive, to get to the heart of the issues of of the individual nominee. And again, sir, I try to summon the spirit of some of the elder statespeople I had the privilege of serving with, from Rockefeller to Levin to McCain, to summon that spirit to be as objective as possible. I do not think it is unreasonable for us to wait for a week or two to get the full body of those documents. It will cause no harm or damage, except to have more of a full telling of what is at stake here. The stakes are too high in what this nominee represents for us to rush through this process without a full sharing of the documents. And with that, I'll continue, sir, with my opening statement. I have said before already that
I'll take this opportunity to probably say that you said I didn't get all the documents I requested. You probably heard the first sentence of something I said after our break, and that was that I first started talking about expecting 1 million documents. And we end up, I think, with 488,000. But then I went on to explain that the process with all the software and everything else that can speed things up, duplicates were eliminated, and et cetera, et cetera. And so we've gotten all the documents I requested, just to correct you.
Sir, and to my understanding—
Go ahead with your opening statement.
No, sir, but I just want to make a point to that, if you don't mind. You requested a limited set of documents of his time in the White House counsel's office. We have not received all the documents from his time. They're still being vetted slowly through a system of not a representative from the committee, but the Bill Burke individual is still reading through those documents as we speak. I imagine some of them will be dumped on us as this process is going on, and I predict with quite confidence that some of those documents might still be trickling out in the days before the actual full Senate vote. Please, sir.
You're talking about committee confidential, and you have access to them right now. There hasn't been a determination that like 80% of all the documents are on the website so the public can see them. But in regard to some, they were forwarded to us without a second review. That second review gives an opportunity to then get them out to the public if there's no reason that they are excluded under the law, and you can read those committee confidential documents right now.
Well, sir, we sent a letter days ago asking for that. I will resend it with you in these next 24 hours before our hearing tomorrow.
We responded to your letter.
Again, sir, you did not respond to our letter by allowing committee confidential documents.
Please go to your opening statement.
Thank you very much, sir. And look, I was, former Senator, now former Vice President Biden talked about not questioning your colleagues' motives. And some of the colleagues across the aisle have called the efforts by some of us sincerely to get access to these documents a sham, a charade. I can go through a lot of the words that were used calling into question the motivations that I have for doing what I believe, sir, is perhaps the most grave and important duty that I have as a senator, to advise and consent. And yes, as Senator Cornyn pointed out, I have announced my decision already, but my duty to the people of the state of New Jersey and others is to fully vet an individual. That's why I think the documents are important, that his full record is made clear and that we have a chance to ask questions about it. I also have said that I oppose this nomination happening right now because of the moment we are in American history, which is very unprecedented. I remind you that we have had bipartisan statements by senators working in tangent about the attack on the United States of America, which was an attack going to the core of what our democracy is about, the voting processes. A special counsel was put into place, and that has led to dozens of people being indicted, people all around the President of the United States. It has led to dozens and dozens of charges, and that investigation is ongoing. We have seen the President of the United States credibly accused by his own personal lawyer as being an unindicted co-conspirator. In all of this, we have one judge being chosen who was not on the original list. He wasn't on the outsourced Federalist Society's original list. He wasn't on the second version of that list. He got onto that list after this special investigation got going. In other words, after the president was in jeopardy. He was added to the list, and then the president pulled the one person from all of that list that it was added late that would give him, in a sense, the ability to pick a judge that has already spoken vastly about a president's ability to be prosecuted, about a president's ability to dismiss or end an investigation. And so that's the second reason why I've asked for us to put a pause on this process. Fundamental to this nation's very beliefs. Judge Learned Hand said this. As powerful and profound as the documents of this country are, our founding documents, they're not worth much if the people themselves lose faith in them. And I believe the nomination of a judge from all of this list that so powerfully speaks to a president's de facto immunity from ongoing investigation prosecution will shake the faith that millions and millions of Americans have in the fairness of the process and the system. And I've asked Judge Kavanaugh time and time again to recuse himself, to restore that faith, to alleviate the concerns of Americans, and he has thus far refused to do so. Now, I am upset about the process. And this is not manufactured outrage. This is sincere concern for a process that seems wrong and just not objective and fair. I am concerned about, as my colleagues are on both sides of the aisle, a Russian attack on our nation. But there's a lot more going on here that makes this nomination of great concern. And it's, frankly, some of the things I've heard from both sides of the aisle tonight is when we travel this country and what we are hearing from individuals and how that relates to a position on the Supreme Court. Right now, millions of American families are watching this in sincere concern and fear. I've heard them. I've gotten the calls. I've traveled this country. I've talked to Republicans and Democrats. They are fearful about where the Supreme Court is going and what it will do when it has the power to shape law, shape the lives and liberties for individuals for decades to come. I've talked to workers all over my state, all over this nation, workers that now work in a country where wages are at a 60-year low as a portion of our GDP, workers whose labor protections are being diluted and whose unions are under attack. So many of those individuals are asking whether the Supreme Court of their lifetimes will be an institution that elevates the dignity of American workers, or one that allows powerful corporate interests to continue to weaken labor protections that didn't just happen, labor protections that were fought for, that people struggle for, that some, if you know the labor movement, actually died for? Are these labor rights going to become aggravated? Are they going to become limited, further increasing the vast disparities of wealth and power in our country? We know this. We've talked to them, both sides of the aisle. We've talked to cancer survivors, Americans with disabilities, survivors of domestic abuse, parents with beautiful children that happen to have disabilities, who, because of the Affordable Care Act, can no longer be denied coverage because of, quote, a pre-existing condition. There's a Texas case where that's being challenged right now. That's moving up. It could likely go before the Supreme Court. Well, knowing your record, it is right that these Americans, so many of them with pre-existing conditions, are asking whether the Supreme Court will be an institution that affirms and protects the rights of people with access to health care. Many people who rightfully believe, when they read our founding documents that talk about life, liberty, and the pursuit of happiness, that health care, they believe, is fundamental. We all know too many people who have set aside prescription drugs because they're too high, because of what corporations are doing there. People who have put off going to see the doctor because a visit is too expensive. That is in the balance with this nomination. I've gone across the state, and Senator Durbin, I don't know if I've told you this, I was in your state talking to a Republican farmer about how the farm country is changing so dramatically. The livelihoods of so many independent family farmers are being threatened by the consolidation of large multinational corporations. These corporations have acquired so much power. This consolidation now, from the seeds that they buy, the prices going up, to who they have the ability to decide to, this abuse of corporate consolidation is driving so many farmers out of business. You see, one farmer was telling me about the suicide rates. Now, people are saying that this is histrionics, this is not life or death. Well, I know these things actually are often a matter of life or death. When uninsurance rate goes up, when insurance rates go down, rather, more people without health care often lose their lives. There's not one senator on the Republican side or Democratic side who has not seen, I've only been here 5 years, and I've seen the culture of Washington change because of the obscene amount of dark money pouring into our political process, corrupting our political process, rigging the system. This nomination will have an effect on that. I've seen Americans all over this country, it's the bipartisan work that I've done with senators on the other side who feel entrapped by a broken criminal justice system, one that is, we know, and unassailably disproportionately targets black and brown Americans. Where many Americans believe, and one famous American said, we have a system that now treats you better if you're rich and guilty than poor and innocent. These issues are in the balance now. And everyone who's concerned about these issues and more are wondering what the story of America is. We have this great leader, a man named King, who said the arc of the moral universe is long, but it bends towards justice. There are so many Americans who fought for these fundamental rights, who family members, who they remember, union organizers, civil rights activists, women's rights activists who fought for, struggled for, and died for many of these rights. The right for women to make their own medical decisions, including the right to an abortion and not a back alley butcher. The right of all Americans to marry who they love. The right to vote and to work free of discrimination regardless of race, and the rights of all Americans. These are our rights. These are our American rights. And so we know the answer to these questions. I have looked through the record I've had access to see the pattern of your decisions. And that's the pattern that really troubles me, Judge, and I know we're going to get a chance to go through this. And I know my colleagues will as well, but it seems so clear that in your courts, the same folks seem to win over and over again. The powerful, the privileged, big corporations, special interests, and over and over again, the folks that lose are the folks that, why I came to Washington to fight. Working folks, consumers, women, immigrants, minorities, the disadvantaged, the poor. This is the challenge before us. This is why so much is at stake. I love that my colleagues keep going back to the Constitution, but understand this, I laud our founders. I think they were geniuses, but you got to understand that there are millions of Americans who understand that they were also flawed people. We're the oldest constitutional democracy. We're the oldest one. We were founded in a break with human events. You know this, Judge. I've read your writings. We were not founded on some kind of tribalism as much as we think it's breaking out in our country. We weren't founded because we all look alike, we all pray alike, because we're all the same race. We're not a monarchy, theocracy. We broke with the course of human events and formed this nation. God bless America. God bless our founders. But we know our founders and their values and their ideals. We know that they were flawed. And you can see that in the documents. Native Americans were referred to as savages. Women weren't referred to as all. African Americans, blacks, slaves were referred to as fractions of human beings. As one civil rights activist, I think it was Stokely Carmichael, used to always say, constitute, constitute. I can only say 3/5 of the word.
Senator Booker.
But I'm almost done, sir.
Okay, go ahead.
I've got about 3 more minutes.
The only reason I stopped you at this point is I thought that I would let people go at least as far as Senator Blumenthal went, and you have reached that point. But
I appreciate that. I'm a bit of a trailblazer, sir. I'm going to push just 2 or 3 more minutes.
Okay.
My point, sir, is that I'm proud of this history.
Your clock, when it reaches 10, is your 2.5 minutes.
And I just want to point out right here, from the activism of Stonewall, Selma, Seneca Falls, there's an activism that I worry rights that were gained were rolled back. And the example I have here is there's an amazing activist here right now, Miss Carlotta Walls Lanier. And Ms. Lanier, I thank her for coming today. It was 61 years ago on this very day, on September 4th, 1957, that Ms. Lanier, at the age of 14, faced crowds that were shouting racial slurs. She was jeered. And on that day, Ms. Lanier joined 8 other students, a group that would become known as the Little Rock Nine, to try to desegregate an all-white high school in Little Rock, Arkansas. We know what they did that day was much bigger than a first day of school. It was the first major test of the Supreme Court's landmark decision, the 1954 Brown versus Board of Education decision. I've been shocked sitting here that there are now some judges that Trump has appointed that refuse to even say, and I'm not saying this is you, sir, that that's settled law. There are people like Ms. Lanier who are part of gaining rights in this country, advancing the ideals of this nation towards the purity of the ideals put forth by the founders despite the imperfections. And now the fear and the worry is, where the trend of the court is doing, is rolling back those gains, is undermining that progress, is restricting individual rights as the rise of corporations, the rise of dark money, the rise of the interests of the powerful and the privileged and the elite. And so I just say in conclusion, sir, I said this to you in a heart-to-heart moment in the last seconds that you came to my office to meet with me one-on-one, which I appreciated. I pointed to the map behind my desk, which is the Central Ward of Newark, New Jersey, a place with mighty people. It's a low-income community, people still struggling for the fullness and the richness of the promises of America. That's the concern that I have right now. That is what is at stake. And so I say in conclusion, sir, this to me is a profound and historical moment. I cannot support your nomination, not just because of the body of your work, but also the perverse process by which this comes forward. We should not vote now. We should wait. And if we're not waiting, we should object to your nomination. Thank you.
Senator Tillis.
Thank you, Mr. Chairman. I have a 12-minute preamble and 18 minutes of comments. In all seriousness, I hope to beat Senator Flake in being brief. First off, to Ashley, I know that Margaret and Liza are gone, but you've gone through a very difficult day, and you've held up well. To your parents, Judge Kavanaugh, I've got to compliment you on your mother's composure. I'm pretty sure my mother would have been out of the chair by now. So I appreciate all that you've done. You've obviously raised your son right. You know, I think we need to go back and recognize we were going to be here. This wasn't going to be a kumbaya moment. We had every member on this committee either publicly state or participate in a press conference before the sun had set on the first 24 hours of your nomination that they were going to vote against you. Now we're asking for all kinds of documents, and you're getting them. As a matter of fact, I think that the chair has done an extraordinary job. He started out on this process by acquiring as many as 1 million documents. We determined because of duplication and relevance, it was only 500,000. And they've all been provided. And I'm not an attorney, but I am a technologist. And I'm also a process person. And I know damn well that if you get documentation electronically, you can get through it in a matter of hours. And for the documents that got sent yesterday, you could get through it in a matter of hours. They have plenty of time to get documents that they only need to run up the score because they already know they're going to vote against you. I also want to compliment you on your composure. You've taken a lot of notes. And I, for one, tomorrow are going to spend more of my time listening to your responses rather than talking over you and try to simplify things into yes, no, or answers that you know you can't respond to. So I look forward to your testimony tomorrow. As the hearing was going on, there were two things that just caught me. I'm not doing my prepared statements. I'll submit them for the record, Mr. Chair, but we're talking about all this dark money and efforts going on the other side. Well, I just got an email from Organizing for Action. Y'all would know that as the legacy campaign of President Obama, telling me to oppose you because you're going to deny reproductive rights, deny health care coverage, advance climate change in a bad way, and end gun violence prevention. I don't know near as much about the institutions of government as, let's say, Senator Sass, but I'm pretty sure once you get confirmed on the bench, you're not going to be able to file a bill to do any of that. What you may end up doing is finding out that we got lazy, we didn't work hard enough, we didn't understand the Constitution, we didn't reach across the aisle to create enduring value, which is largely the reasons why people get frustrated with you. They want you to do our job. Justice Gorsuch said numerous times in his confirmation hearing that I had the privilege of participating in, it's not my job to do your job, Mr. Senator. If you're frustrated and worried about the prospects of somebody being denied coverage for pre-existing convictions, then let's fix it. That's why I filed a bill a couple of weeks ago. Let's fix it. Don't play politics and blame the Supreme Court for your inadequate architecture of a bill. Let's fix it. If you're worried about the balls and strikes that Judge Kavanaugh has called on the bench around regulatory issues, it seems to me you've called balls and strikes on both sides of the Administrative Procedures Act. And there seem to be flaws in there that need to be fixed. For the attorneys in the room who are studied on the law, rather than trying to get Judge Kavanaugh to commit one way or the other on these policy initiatives that President Obama and others around this table are interested in, get him to explain to you the legal theory behind his position that may have, in fact, produced an outcome that he didn't particularly like, but because he did it based on his interpretation of the Constitution and the laws. Don't expect him to be a politician. And as for motivations, I have to say that it's been said by at least one person on this committee that on the one hand, we shouldn't question other people's motivations. On the other hand, I find it personally insulting to think that because I think we have before us an eminently qualified judge, someone who's going to call balls and strikes, to suggest that because I'm inclined to support them, that I'm complicit in evil, really makes me wonder the sincerity about questioning other people's motives. So, Judge Kavanaugh, I am glad that you're before us. I believe that you have 300 opinions that people should look at and read and try and spar with you on the basis of your legal knowledge, your constitutional understanding and the statutory constructs. It would be great, and I hope that people have actually taken time to look at the single most important factor in your resume. It's not maybe where you went to school, I guess that's good. It's not maybe where you practice law, but it's the 307 different opinions you can read and the dissents you can read. Spar on the basis of your legal knowledge, those of you who want to prove to be the smartest lawyer in the room, and see if you can actually prove a better theory that may actually give Judge Kavanaugh pause. But that's not what this hearing's been about. And I'm so glad that I'm one of the last people to do an opening statement, because what I hope I hear tomorrow And by the way, just from a process standpoint, we're going to have 30-minute rounds, which in Senate time is about an hour and a half per member, tomorrow. And then we're going to have 20-minute rounds the following day. Everybody take time to actually talk about legal theory. Stop the theater and start talking about what's really meaningful here. And I think if we do that, I have every confidence, Judge Kavanaugh, you're going to be Justice Kavanaugh. And I'm proud to actually see you compose yourself the way you have today. I'll be asking you several questions on some judgments that, frankly, I didn't like. But I know you probably made the right decision. And I believe that when you get confirmed to the bench, you're actually going to take some other opinions that I don't like, because it's what I wished you could do for me because we failed to get it done here. But it will be done for the right reasons. And I think if people objectively look at your record, they're going to be hard-pressed to take all this theater we've heard today and boil it down into something that makes you look like you're an activist judge just waiting to be one of the members of that nine-member legislative branch down the street. I think you're one of the single great opportunities that we have to make the Supreme Court make us do our job and to rein in the dangerously high amount of authority that our administrative branch has. And that's all I want you to do. And I look forward to asking you questions tomorrow. I yield back the rest of my time.
I see Senator Graham has rejoined us. I think he was here before me. He's more senior. Okay, great. So I thank you, Mr. Chairman. I'd like to restate my objection from earlier for the record, which is my motion to postpone this hearing. A number of comments have been made by my honored and respected colleagues. I'd like to address a few of them. One, there was some mention of a concern about Elena Kagan's hearing and that the White House at the time, there was an agreement that those certain records are sensitive and should therefore not be disclosed. It's my understanding that as a point of distinction between that time and today, that those were active cases in the White House, and for that reason there was an understanding and agreement that they were of a sensitive nature and should not be disclosed. In terms of the point that has been made about playing politics and blaming the Supreme Court, I think that we have to give pause when those kinds of concerns are expressed to also think about the fact that there have been many a political campaign that has been run indicating an intention to use the United States Supreme Court as a political tool to end things like the Affordable Care Act, the Voting Rights Act, and campaign finance reform, which makes this conversation a legitimate one in terms of a reasoned concern about whether this nominee has been nominated to fulfill a political agenda as it relates to using that court and the use of that court. As it relates to the 42,000 documents, or 42,000 pages of documents, I find it interesting that we get those documents less than 24 hours before this hearing is scheduled to begin. But it took 57 days for those documents to be vetted before we would even be given those documents. So there's some suggestion that we should be speed readers and read 42,000 pages of documents in about 15 hours, when it took the other side 57 days to review those same documents. So the logic, at least on the math, is not applying. Now, the chairman has requested 10% of the nominee's documents. That's 10% of 100% of his full record. The nominee's personal lawyer has only given us 7% of his documents, 7 out of 100% of the full record. Republicans have only given 4% of these records or made them public. That's 4% of 100% of a full record. 96% of his record is missing. 96% of his record is missing. It is reasonable that we should want to review his entire record, and then we can debate among us the relevance of what is in his record to his nomination. But it should not be the ability of the leadership of this committee to unilaterally make decisions about what we will and will not see in terms of its admissibility, instead of arguing about the weight of whatever is made admissible. The late Senator Kennedy of Massachusetts called these hearings a Supreme Court nominee's, quote, job interview with the American people. And by that standard, the nominee before us is coming into his job interview with more than 90% of his background hidden. I would think that anyone who wanted to sit on the nation's highest court would be proud of their record and would want the American people to see it. I would think that anyone privileged to be nominated to the Supreme Court of the United States would want to be confirmed in a process that is not under a cloud, that respects due process. I would think that anyone nominated to the Supreme Court of the United States would want to have a hearing that is characterized by transparency and fairness and integrity and not shrouded by uncertainty and suspicion and concealment and doubt. We should not be moving forward with this hearing. The American people deserve better than this. So, Judge Kavanaugh, as most of us know, and I will mention to you, and you have young children, and I know they're very proud of you, and I know you are a great parent, and I applaud all that you have done in the community. And so, as you know, as we all know, this is a week when most students in our country go back to school. And it occurs to me that many years ago, right around this time, I was starting kindergarten. And I was in a school bus, on my way to Thousand Oaks Elementary School as part of the second class of students as busing desegregated Berkeley, California public schools. This was decades after the Supreme Court ruled Brown v. Board of Education that separate was inherently unequal. And as I've said many times, had Chief Justice Earl Warren not been on the Supreme Court of the United States, he could not have led a unanimous decision, and the outcome then of that case may have been very different. Had that decision not come down the way it did, I may not have had the opportunities that allowed me to become a lawyer or a prosecutor. I likely would not have been elected District Attorney of San Francisco or the Attorney General of California. And I most certainly would not be sitting here as a member of the United States Senate. So for me, a Supreme Court seat is not only about academic issues of legal precedent or judicial philosophy. It is personal. When we talk about our nation's highest court and the men and women who sit on it, we're talking about the impact that one individual on that court can have. Impact on people you'll never meet and whose names you will never know. Whether a person can exercise their constitutional right to cast a ballot, that may be decided if Judge Kavanaugh sits on that court. Whether a woman with breast cancer can afford health care or is forced off life-saving treatment. Whether a gay or transgender worker is treated with dignity or may be treated as a second-class citizen. Whether a young woman who got pregnant at 15 is forced to give birth or in desperation go to a back alley for an abortion. Whether a president of the United States can be held accountable or whether he'll be above the law. All of this may come down to Judge Kavanaugh's vote. And that's what's at stake in this nomination. And the stakes are even higher because of the moment we're in, and many of us have discussed this. These are unprecedented times. As others have already observed, less than 2 weeks ago, the president's personal lawyer and campaign chairman were each found guilty or pleaded guilty to 8 felonies. The president's personal lawyer, under oath, declared that the president directed him to commit a federal crime. Yet that same president is racing to appoint to a lifetime position on the highest court in our land, a court that very well may decide his legal fate. And yes, that's essentially what confirming Judge Kavanaugh could mean. So it is important, more important, I'd say, than ever, that the American people have transparency and accountability with this nomination. And that's why it is extremely disturbing that Senate Republicans have prevented this body, and most important, the American people, from fully reviewing Judge Kavanaugh's record and have disregarded just about every tradition and practice that I heard so much about before I arrived in this place. Judge Kavanaugh, when you and I met in my office, you said, with respect to judicial decisions, that rushed decisions are often bad decisions. I agree with you. I agree with you. And when we are talking about who will sit on the Supreme Court of the United States, I believe your point couldn't be more important. Mr. Chairman, when Judge Kavanaugh was nominated in July, he expressed his belief that a judge must be independent, must interpret the law, and not make law. But in reviewing this nominee's background, I am deeply concerned that what guides him is not independence or impartiality. It's not even ideology. I would suggest it is not even ideology. What I believe guides him, and what his record that we've been able to see shows, is what guides this nominee is partisanship. This nominee has devoted his entire career to a conservative Republican agenda, helping to spearhead a partisan investigation into President Clinton, helping George W. Bush's legal team ensure that every vote was not counted in Bush v. Gore, helping to confirm partisan judges and enact partisan laws as part of the Bush White House. And in all of these efforts, he has shown that he seeks to win at all costs, even if that means pushing the envelope. And if we look at his record on the D.C. Circuit, and in his recent writings and statements, it is clear that the nominee has brought his political bias to the bench. He has carried out deeply conservative partisan agendas as a judge, favoring big business over ordinary Americans, polluters over clean air and water, and the powerful over the vulnerable. Just last year, Judge Kavanaugh praised the dissent in Roe v. Wade and ruled against a scared 17-year-old girl seeking to end her pregnancy. He has disregarded the Supreme Court precedent to argue that undocumented workers weren't really employees under our labor laws. We have witnessed horrific mass shootings from Parkland to Las Vegas to Jacksonville, Florida. Yet Judge Kavanaugh has gone further than the Supreme Court and has written that because assault weapons are, quote, in common use, assault weapons in high-capacity magazines cannot be banned under the Second Amendment. When he was part of an independent counsel investigation into the Democratic president, the nominee was dogged in demanding answers. And yet, he has since changed his tune, arguing that presidents should not be investigated or held accountable, a position that I am sure is not lost on this president. These positions are not impartial, they are partisan. Judge Neil Gorsuch, Judge Kavanaugh's classmate, insisted before this committee that judges are not merely, quote, politicians in robes. I fear that Judge Kavanaugh's record indicates that is exactly what he may very well be. Now, I know members of this committee and the nominee's friends and colleagues have assured us that he is devoted to his family and supportive of his law clerks and volunteers in his community, and I don't doubt that at all. But that's not why we are here. I'd rather that we think about this hearing in the context of the Supreme Court of the United States and the impact it will have on generations of Americans to come. And do we want that court to continue a legacy of being above politics and unbiased? Or are we prepared to participate in a process that is tainted and that leaves the American public questioning the integrity of this process? And I'll close by saying this. We have a system of justice that is symbolized by a statue of a woman holding scales, and she wears a blindfold. Justice wears a blindfold because we have said in the United States of America, under our judicial system, justice should be blind to a person's status. We have said that in our system of justice, justice should be blind to how much money someone has, to what you look like or who you love, to who your parents are and the language they speak. And every Supreme Court justice must understand and uphold that ideal. And, sir, should those cases become before you, Judge Kavanaugh, I am concerned whether you would treat every American equally, or instead show allegiance to the political party and the conservative agenda that has shaped and built your career. I am concerned your loyalty would be to the president who appointed you and not to the Constitution of the United States. These concerns, I hope you will answer during the course of this hearing. I believe the American people have a right to have these concerns. I also believe the American public has a right to full and candid answers to the questions that are presented to you during the course of this hearing. I will be paying, of course, very close attention to your testimony, and I think you know the American public will be paying very close attention to your testimony. Thank you.
Senator Graham.
Am I the last person?
Yes.
All right.
But don't forget, we're going to hear from the nominee and his introducers before you can go home and go to bed.
Okay, thank you. I was going to ask you to take me to dinner, but that's not going to happen.
You know the answer to that.
You know that, that's right. So, to my colleagues on the other side, I look forward to working with you, but we have a different view here. I think you got to be blind as to what's going on here. Have you heard of Justice Breyer? Do you know him? You can't say anything, I guess. Where did he come from? He was Ted Kennedy's Senate Judiciary person.
Chief of Staff.
Where do you think Republicans are going to go find a judge? The whole argument is you can be a conservative Republican president, but you got to nominate a liberal to be fair to the country. That's absurd. Where do you think Ruth Bader Ginsburg came from? She was the general counsel of the ACLU. Wonderful person. What groups do y'all use to pick from? This is shaping up to be the hypocrisy hearing. And that's hard to do in the Senate in today's time, to be hypocritical. But let me just point to a few of these things. Clinton. It didn't bother anybody for Clinton to nominate Breyer while he was under investigation. We actually did it. It didn't bother any of y'all that Ted Kennedy, staff person, was his pick. It didn't bother me either, because that's who I expect you to pick. This is ridiculous. You're one of the best choices any Republican could make. As I said with Justice Gorsuch, I am glad you're here because there were days I'm wondering who he would have picked. And this is a home run from my point of view. Let's talk about Roe v. Wade. Who would ever play politics on the campaign trail with Roe v. Wade? What a bastard Donald Trump is. Until you hear about Hillary Clinton. February the 3rd, 2016. Here's what Hillary Clinton said. When asked, does she have a litmus test for SCOTUS nominations, Supreme Court nominees? I do have a litmus test. I have a bunch of litmus tests because the next president could get as many as 3 appointments, and I hope she's right. We've got to make sure to preserve Roe v. Wade, not let it be nibbled away or repealed. She sounds very open-minded. October 2016. We need a Supreme Court that will stand up on behalf of women's rights. It is important that we not reverse Roe v. Wade. I want a Supreme Court that will stick with Roe v. Wade and a woman's right to choose. I understand where she's coming from. Anybody running for president over there, I dare you to disagree with her. You will wind up like I did, getting 1%. If you even suggest that you will pick a nominee that's not going to uphold Roe v. Wade, that's the end of you. But you figured that out. You don't need me to tell you. So this is the way we do politics. This is a big decision called Roe v. Wade. There are 2 sides and a bunch of nuances. Here's what I know about you. You're going to take it as president. You wrote a big book, which I will never read. and you're going to tell us what it takes to overturn longstanding precedent. Nobody on this side will care if you overturn Citizens United. Matter of fact, they will cheer you on. Somebody will challenge Citizens United, and you'll probably say, let me hear both sides of the story, then I'll tell you whether or not I should uphold it. Hillary Clinton, we know where she's at on Roe v. Wade, and that's just the way it is. Now, what other things? Executive power. This idea that Trump picked you to save him. Amazing concept. Since you said what you said back in 1998 and 2008, the bottom line is when Clinton was being impeached, my good friend, and this is true, he is my good friend, on February 12, 1999, introduced into the record during the deliberations of the Clinton impeachment trial an article by Brett Kavanaugh suggesting that you should wait, if there is an indictment, until after the president is out of office. The same concept we're talking about here today, when the shoe was on the other foot. Here's what Joe said about your thinking. The president is not simply another individual. He is unique. He is the embodiment of the federal government and the head of a political party. If he is to be removed, the entire government likely would suffer, and the military or economic consequences to the nation could be severe. These repercussions, if they are to occur, should not result from the judgment of a single prosecutor, whether it be the Attorney General or Special Counsel, and a single jury. Prosecution or non-prosecution of president is, in short, unavoidably a political act. Thus, as the Constitution suggests, the decision about the president while he's in office should be made where all great national political judgments in our country should be made in the Congress of the United States, according to Joe Biden, the gift that keeps on giving for us. I think that's pretty hypocritical. During the Clinton days, you were right, but all of a sudden you're a danger to the republic. Let's talk about, there's so many. How many minutes do I have here? The bottom line is...
Don't exceed what White House.
I will not.
That'd be impossible.
Guns. Somehow you're going to make sure that Congress, the bottom line on guns, Dianne Feinstein's a wonderful lady and has passion on this issue about assault weapons. She was able to succeed politically. After 10 years, the gun assault weapons ban expired, and it's been hard to get it reestablished. She introduced legislation in 2013 that got 60 no votes, 16 Democrats. So I don't believe they see you as a threat to the nation if you come out on the idea that the Second Amendment has some meaning. In other words, the political process when it comes to guns is a work in progress, and I'd rather us decide that than you. When it comes to the pillar of virtue, Comey. Harry Reid, that he's been a supporter of Comey and led the fight to get him confirmed, as he believed Comey was a principled public servant. With the deepest regret, I now see that I was wrong. Mr. Nadler from New York. The president can fire him for cause and ought to. He violated all the guidelines and put his thumb on the scale of an election. Mr. Cohen from Tennessee, a Democrat, called on Comey to resign his position effective immediately. I'm sure upon reflection of this action, he will submit his letter of resignation for the nation's good. To my Democratic friends, you are all for getting rid of this guy. Now all of a sudden the country is turning upside down because Trump did. There's a process to find out what happened in the 2016 election. It's called Mr. Mueller. And I will do everything I can to make sure he finishes his job without political interference. And I'm here to tell anybody in the country who listens that this is so hypocritical of my friends on the other side. When it was their president, Kavanaugh was right. When you're talking about Roe v. Wade, it's okay to promise the nation it will never be overturned. It's okay to pick a Democratic staff member of this committee, but it's not okay to pick somebody who's been a lifelong Republican. People see through this. You had a chance and you lost. If you want to pick judges from your way of thinking, then you better win an election. I voted for two of your choices, Sotomayor and Kagan. Got a lot of crap. I would suggest you think long and hard if you got a political ambition of voting for this guy, because it will not play well on your side. And why did I do it? I thought they were qualified by any reasonable measure given the history of the Senate. But we have turned the history of the Senate upside down. I found that they were different than I would have picked Sotomayor and Kagan, but by any reasonable measure, they were qualified. You've been on the court for 12 years. You've had 307 decisions. You've been approved before. So I hope people in the country understand this game. It's a game that I am sad to be part of. It's gotten really bad. The antidote to our problems in this country when it comes to judges and politics is not to deny you a place on the Supreme Court. This is exactly where you need to be. This is exactly the time you need to be there. And I am telling President Trump, you do some things that drive me crazy. You do some great things. You have never done anything better, in my view, than to pick Gorsuch and Kavanaugh, because you had an opportunity to put well-qualified conservatives on the court, men steeped in the rule of law, who will apply analysis, not politics, to their decision-making, and you knocked it out of the park into my friends on the other side. You can't lose the election and pick judges. If you want to pick judges, you better win.
Let me tell you what, let me tell everybody what the rest of the day holds for us. Judge Kavanaugh, you can take a break now that we had originally scheduled for 15 minutes, and it may take 15 minutes, but we got to put a different table in here for the people that are going to introduce you. So if your staff will watch and we get done in less than 15 minutes, I'd like to start just as soon as the table is set. So we'll take a 15-minute break now, and then we have the introducers, and then we will give the oath to the nominee, and then we will hear the statement from the nominee, and then we will adjourn until 9:30 tomorrow morning. And tomorrow morning, my approach is going to be the same for the 30 minutes as it would be for the 5 minutes that we normally have in just an otherwise normal hearing. And that is that if you got 1 second left, you can ask a question, but don't take all day to ask a question. And I hope you can give a short answer if their time is up. Then we'll move on to the next person. So I want tomorrow not to happen. Maybe I better speak to myself. I'm not going to let happen tomorrow what I shouldn't have let happen today, because I've been instructing people that run committees, either you run the committee or it runs you. And you guys have been very successful today in running the committee. I don't want it to happen tomorrow. Take your time, sir. Or I mean, until we get the table set. Recess.
And still to come today, more of the confirmation hearing for Supreme Court nominee Judge Brett Kavanaugh. Expecting to hear introductions by Ohio Senator Rob Portman, who's helped lead the efforts in the Senate to confirm him. We'll also be hearing from former Secretary of State Condoleezza Rice, who worked with Judge Kavanaugh at the White House during the George W. Bush administration. And we'll hear an introduction by attorney Lisa Blatt, who was actually a clerk for Justice Ruth Bader Ginsburg. Ms. Blatt wrote an opinion piece in Politico supporting Judge Kavanaugh's appointment. All those to come, plus the nominee's statement, himself speaking probably toward the end of this hearing today. And if you missed any of the hearing that we've been showing you live here on C-SPAN 3, we'll be showing it again tonight. You can join us over on C-SPAN 2 at 8 p.m. The questioning of Judge Kavanaugh expected to begin tomorrow and continue through Thursday. And again, just to let you know, still to come in the hearing today, expecting introductions by former Secretary of State Condoleezza Rice and others. And then finally, the opening statement by the nominee himself, Judge Kavanaugh. A reminder, you can monitor some tweets from the committee members and the Supreme Court reporters. They're all collected in one place during the hearing. If you go to our website, cspan.org, and click on the tab that says Supreme Court, you'll see a link in red that will take you to our coverage of the hearing, and those are scrolling along the right side of the page. You can see what members and reporters are tweeting as the hearing is underway. We also heard from Democrats this morning. They're on the Judiciary Committee about their concerns. You can find their press conference in our archive online, cspan.org. And the chair of the committee, Chuck Grassley, promising before this break he would take control of the committee. It got a bit of a late start this morning because of the number of protesters that were in the room, also because Democrats requested that the hearing be adjourned until they had time to go over documents they received last night, more than 40,000 pages worth.
Take the binder.
We are fortunate to have Condoleezza Rice, Senator Rob Portman, and Lisa Blatt to introduce the nominee. We will now start with Condoleezza Rice.
Thank you very much. Chairman Grassley, Senator Feinstein, members of the committee. I'm really honored to join Lisa Blatt and Rob Portman in introducing Brett Kavanaugh at these hearings to consider his confirmation as a justice of the Supreme Court of the United States of America. My personal relationship with Judge Kavanaugh goes back 17 years to our time as White House colleagues in the administration of George W. Bush. Those were remarkable times, and I loved serving. They were, however, not easy times. And the guidance and counsel of those with whom I worked was both a joy and a blessing. I am so grateful to have had Brett Kavanaugh as a colleague. He was always supportive and strong and caring, and someone whose integrity and good judgment I valued enormously. I knew Brett early in his years as a family member. As a matter of fact, I was there when he married Ashley. I remember well the birth of his children. He is a great father and husband and son. In short, he's just a very good human being. Since the nomination of Brett Kavanaugh, I have been able to reflect back on those times and what my experience tells me about Brett in this crucial role. Many have given testimony to his extraordinary legal mind, the depth of his experience, his intellect, and his good common sense. You have heard and you will hear from his clerks and other jurists and great legal thinkers, as well as colleagues from throughout his career. I do not need to repeat their praise, only to say that I know firsthand that Brett is really, really smart. Here's the Brett Kavanaugh that I know. He is hardworking. He has a sense of humor. He seeks truth in facts. There is no detail too small to gain his attention. He makes those around him better. Brett is wise. He is an old soul who is made to help steady us in these complicated times. Brett listens, especially to those with whom he disagrees. And in our charged environment, when we have become almost tribal, living in echo chambers and often finding comfort in the company of only those with whom we agree, this is an indispensable quality for the responsibilities of the Supreme Court. The only thing that would be better is if Brett had gone to the same college that his mentor and friend Anthony Kennedy went to. That would be Stanford University. But for that, I'll forgive him, and I have to say Yale University seems to have done a pretty good job. In recent weeks, we've also had the chance to reflect on our Constitution, the Supreme Court itself, and the trust that we place in the justices of it. As a scholar and as a diplomat, I have watched the struggle of people across the world to achieve democracy and to keep it. Every day, I am more amazed by the brilliance of the institutional design that the framers left to us. They carefully balanced powers and responsibilities between the three branches of government. Knowing that human beings are fallible, they constructed institutions that both enable and constrain those who would govern us. Scholars often speak of the American spirit of constitutionalism. We Americans believe that the Constitution is our personal protection. We take our rights very seriously, and we will go all the way to the Supreme Court if we think those rights have been violated. A democracy is only stable when there is that kind of trust in the institutions, a belief that those institutions will be fair and just and secure the rights of citizens. The strength of America's institutions is a cause for optimism, but they cannot be taken for granted. The Supreme Court's special role in protecting the careful balances that the Constitution seeks to achieve is crucial to our democratic stability. This is true even as times and customs change, and it is more important with every passing year in our increasingly complicated nation. As a little girl born in segregated Birmingham, Alabama, who grew up to be Secretary of State, I know personally our country's long journey to guarantee equal rights. I know the power of the Constitution, and I know the gift of our democracy. The Supreme Court is a crucial guardian both of our Constitution and of our democracy. That is why I am so honored to introduce Brett Kavanaugh for these hearings. He will be an outstanding Supreme Court justice. His intellect is unquestioned. His judgment is highly regarded. And I can personally attest to his character and integrity as a colleague. Brett Kavanaugh will thoroughly and faithfully uphold the trust that is our heritage, the Constitution of the United States of America, the most remarkable governing document in human history. Thank you.
Thank you, Secretary Rice. Now, our colleague, Senator Portman.
Chairman Grassley, Ranking Member Feinstein, and colleagues on this committee, on the Republican and the Democratic side, it's a privilege to join Condi Rice and Lisa Blatt here this afternoon in introducing a friend, Judge Brett Kavanaugh. I have known Brett and his wife, Ashley, since before they were married, and I had the opportunity to work with Brett during his service in the George W. Bush White House. As Secretary Rice has just said very well, those of us who worked with him universally praise his work ethic, his intelligence, and his integrity. I visited with George W. Bush a few days ago, and we talked about Brett. He put it simply, Brett Kavanaugh is a class act. In endorsing Brett, former lawyer to President Bill Clinton, Bob Bennett, called him a strong advocate of decency and civility. By the way, of all the attributes you look for in a judge, what could be more important than good judgment? Brett definitely showed good judgment in marrying Ashley. So did she. And they're a great family. It's wonderful to have their daughters, Margaret and Liza, with us here today. Brett's parents, Edward and Martha, are also here. That's especially appropriate since Brett's first introduction to the law came from listening to his mom practice closing arguments at the dinner table. She was a trailblazer who went to law school at age 34 and eventually became a trial judge. Brett has said to him, Martha Kavanaugh will always be the true Judge Kavanaugh. During the process of this hearing, there will be more spirited discussions about Brett's legal philosophy and his experience and background as a lawyer and a judge. I heard quite a bit of it already today. And there should be this discussion. This is about a lifetime appointment to the highest court in the land. In my view, there is not a better qualified person to be on that court. Just last Friday, the American Bar Association gave Judge Kavanaugh a unanimous, well-qualified rating, which is the highest rating they offer, unanimous. I saw how he conducted himself as associate counsel to the president in the White House counsel's office, a job I once had in the first Bush White House. And I have watched him for the past 12 years on the D.C. Circuit, where he has been praised as fair, smart, and independent. He has authored more than 300 published opinions, an impressive number, and the Supreme Court has adopted his reasoning a remarkable 13 times, a testament to his thoughtful and well-reasoned decisions, and a record that few, if any, other appellate judges can match. Again, no one more qualified. For more than a decade, he has also taught classes at Harvard, Yale, and Georgetown law schools. He is a well-respected judge and a well-respected professor, and a thought leader among his peers. That's why so many of his former students, his law clerks, his judicial colleagues, and legal scholars, by the way, from across the political spectrum, have come out in support of his nomination. Judge Kavanaugh is guided by the Constitution and by the rule of law. He has said, the judge's job is to interpret the law, not to make the law or make policy. I agree. And by the way, as do most of the people we represent. Judges shouldn't be legislating from the bench. Clearly, Brett Kavanaugh has the right qualifications, and he has a judicial philosophy that is very much in the mainstream. Just as important to me is the kind of person you want on the Supreme Court. I have known Brett not so much as a legal scholar or a judge or a professor, but as a friend, a father, and a husband. He is thoughtful and compassionate, and someone who has a big heart, and the humility to listen. To me, that might be the single most important attribute for a member of the Supreme Court, the humility to listen. Throughout this confirmation hearing, I hope the American people will get to know the Brett Kavanaugh I've had the privilege of knowing. A couple days after he was announced, Brett came to my office one evening to discuss his confirmation, just as he's been to your offices. He then went straight from our meeting to serve dinner to the homeless through his church, a regular occurrence that was long scheduled long before his nomination. I only found out about it because that night someone recognized him and took a photo that got tweeted. And it was a photo of him in a baseball cap in this soup kitchen. It's classic Brett that he didn't tell me this was where he was going after meeting with me. To my colleagues, I know the man. He does things because it's the right thing to do. Brett's also involved, as some of you know, in his daughter's sports teams. Last season, Margaret's sixth-grade girls basketball team he coached had an undefeated season and went on to win a citywide championship. Way to go, Margaret. To show you where his priorities are, Judge Kavanaugh, or Coach K, as he is known by his players, has the team photograph and trophy prominently displayed in his judicial chambers. Julie O'Brien, whose daughter goes to school with Margaret, has another telling story about Brett. A few years ago, Julie's husband passed away. With no one to accompany her daughter to the annual father-daughter dance, Brett stepped up That year and every year since, Brett has taken her daughter, alongside his own, to the dance. It's the kind of person he is. That's the Brett Kavanaugh I know. I'm proud to introduce Brett Kavanaugh before this committee, and I'm proud to strongly support his nomination to be the next Associate Justice of the United States Supreme Court. I know these are partisan times here in Washington, but this is an extraordinary nominee in every respect. Based on his record, his qualifications, and his character, I believe he deserves broad support. My hope, Mr. Chairman, is that, as was the case with Justices Sotomayor and Kagan, nominated by President Obama, this committee will report his nomination favorably, and the full Senate will confirm him with a strong bipartisan vote that he deserves. Thank you, Mr. Chairman.
Thank you, my colleague. Ms. Lisa Blatt.
Thank you, Mr. Chairman and committee members. It is a privilege to appear before you today. My name is Lisa Blatt, and I know Judge Kavanaugh in my capacity as an appellate lawyer here in Washington. I have argued 35 cases before the Supreme Court of the United States, more than any other woman in history. I am also a liberal Democrat and an unapologetic defender of a woman's right to choose. My hero is Justice Ruth Bader Ginsburg, for whom I had the great fortune of serving as a law clerk. I proudly voted for Hillary Clinton. I voted for President Obama twice. And with my apologies, Mr. Chairman, for this one, I wish Senator Feinstein were chairing this committee. And yet, I am here today to introduce Judge Kavanaugh and urge the Senate to confirm him as the next Associate Justice of the Supreme Court. I've received many angry calls from friends and even strangers for supporting Judge Kavanaugh. But I was raised to call it like I see it, and I don't see the choice before you as difficult. By any objective measure, Judge Kavanaugh is clearly qualified to serve on the Supreme Court. After law school, he clerked for Justice Anthony Kennedy, the justice he would succeed. He spent 12 years on the nation's most prestigious Court of Appeals, the United States Court of Appeals for the District of Columbia Circuit. His opinions are invariably thoughtful and fair, and many are known as instant classics, not just because they are important, but because they are written so clearly and well. The Supreme Court has adopted the reasoning in his opinions more than a dozen times. Judge Kavanaugh's judicial temperament and integrity are also flawless. He is meticulously prepared, and he treats litigants with respect, asking probing questions of both sides. He approaches judging by determining what the law requires, no matter his personal preference. Judge Kavanaugh has taught at the nation's top law schools, published thoughtful law review articles, and co-authored a leading treatise on judicial precedent. And as just mentioned, the ABA strongly endorsed him because, quote, he meets the very highest standards of integrity, professional competence, and judicial temperament. On a personal level, I just can't say enough nice things about the judge. I first met him almost 10 years ago when he emailed me completely out of the blue to say that he liked an article I had written about arguing before the Supreme Court. Since then, we've become friends, and he has become a mentor to me in my career. Judge Kavanaugh has spent countless hours listening to me talk about the challenges I have faced as a working mother in a profession dominated by men. He has been a great source of advice on these and many other issues about work-life balance. He understands that life is not always perfect, and he responds to life's challenges with a self-deprecating sense of humor. More generally, Judge Kavanaugh has been remarkably committed to promoting women in the legal profession. More than half of his law clerks have been women, something that is sadly by no means common. And almost all of his clerks, women and men, have gone on to clerk at the Supreme Court, including for Justices Kagan and Sotomayor. As his former women law clerks told this committee, the legal profession is, quote, fairer and more equal because of Judge Kavanaugh. He's mentored countless other women through the classes he teaches at Yale and Harvard law schools. Obviously, I know that Judge Kavanaugh has a conservative judicial outlook. And if he is confirmed, he will have 1 of 9 votes to definitively decide the meaning of the Constitution, including just how far to read it to protect the reproductive rights of women. Now, if it were up to me, Justice Ginsburg would have all 9 votes. But that's not our system, and the reality is that the presidency and the Senate are in Republican hands. Judge Kavanaugh is the best choice that liberals could reasonably hope for in these circumstances. I am sure that some members of the Senate knew that they would disagree with Justice Ginsburg's legal views when she was a nominee, but Justice Ginsburg was confirmed 96-3. This body has obviously treated some nominees differently since then, to the detriment of our courts. I strongly disagree with the Senate's treatment of Judge Garland. Judge Kavanaugh himself spoke glowingly of Judge Garland during his pending nomination, stating that, quote, Chief Judge Garland is a brilliant jurist. He's thoughtful, he's considerate, he's collegial, he works well with others, he's a good man, great integrity, and he is supremely qualified by the objective characteristics of experience, temperament, writing ability, scholarly ability for the Supreme Court. All of this is equally true of Judge Kavanaugh. I do not think it is fair to hold Judge Kavanaugh responsible for the fact that Judge Garland is not a justice today. Instead, I would urge this committee to treat him as we expect him to treat litigants that appear before him, on his own merits and with an open mind towards someone whose views may differ from our own. Our judicial system is not well served by tit-for-tat politics. At the end of the day, I enthusiastically support Judge Kavanaugh, and I am proud to introduce him because he is unquestionably qualified by his extraordinary intellect, experience, and temperament, and he does easily fit within the mainstream of legal thought. I look forward to the committee over the next few days getting to know the Judge Kavanaugh that I know, and at the end of that process, I hope you will agree that he should be confirmed to succeed his former boss on the Supreme Court.
Thank you, Ms. Blatt. Thanks each of the panel for their introduction, and you're dismissed now. And then, Judge Kavanaugh, can you shake your head? I was told that you might want 5 minutes right now. Do you need that? Okay. Then just stay seated till we change the table a little bit, and then we'll get to you. Judge Kavanaugh, do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Proceed with your statement, or anything else that you want to tell the committee right now.
Thank you, Mr. Chairman, Senator Feinstein, members of the committee. I thank Secretary Rice, Senator Portman, and Lisa Blatt for their generous introductions. They are patriots who represent the best of America. I'm humbled by their confidence. I'm proud to call each of them a friend. Over the past 8 weeks, I've witnessed firsthand the Senate's deep appreciation for the vital role of the American judiciary. I have met with 65 senators, including almost every member of this committee. Those meetings are sometimes referred to as courtesy calls, but that term understates how substantive and personal our discussions have been. I have greatly enjoyed all 65 meetings. In listening to all of you, I have learned more about our country and the people you represent.
Every senator is devoted to public service and the public good. And I thank all the senators for their time and their thoughts. I thank President Trump for the honor of this nomination. As a judge and as a citizen, I was deeply impressed by the President's careful attention to the nomination process and by his thorough consideration of potential nominees. I'm also very grateful for his courtesy. At the White House on the night of the announcement, the President and Mrs. Trump were very gracious to my daughters, my wife, and my parents. My family always cherished that night, or as my daughter Liza calls it, her debut on national television. As a nominee to the Supreme Court, I understand the responsibility I bear. Some 30 years ago, Judge Anthony Kennedy sat in this seat. He became one of the most consequential justices in American history. I served as his law clerk in 1993. To me, Justice Kennedy is a mentor, a friend, and a hero. As a member of the court, he was a model of civility and collegiality. He fiercely defended the independence of the judiciary, and he was a champion of liberty. If you had to sum up Justice Kennedy's entire career in one word, liberty. Justice Kennedy established a legacy of liberty for ourselves and our posterity. I'm here today with another of my judicial heroes, my mom. 50 years ago this week, in September 1968, my mom was 26 and I was 3. At that time, my mom started as a public school teacher at McKinley Tech High School here in Washington, D.C. 1968 was a difficult time for race relations in our city and our country. McKinley Tech had an almost entirely African-American student body. It was east of the park. I vividly remember days as a young boy sitting in the back of my mom's classroom as she taught American history to a class of African-American teenagers. Her students were born before Brown versus Board of Education or Bowling versus Sharp. By her example, my mom taught me the importance of equality for all Americans, equal rights, equal dignity, and equal justice under law. My mom was a trailblazer. When I was 10, she went to law school at American University and became a prosecutor. I am an only child, and my introduction to law came at our dinner table when she practiced her closing arguments on my dad and me. Her trademark line was, "Use your common sense. What rings true? What rings false?" One of the few women prosecutors at the time, she overcame barriers and was later appointed by Democratic governors to serve as a Maryland state trial judge. Our federal and state trial judges serve on the front lines of American justice. My mom taught me that judges don't deal in abstract principles. They decide for real cases, for real people in the real world. And she taught me that good judges must always stand in the shoes of others. The chairman referred to me today as Judge Kavanaugh, but to me, that title will always belong to my mom. For 12 years, I've been a judge on the U.S. Court of Appeals for the D.C. Circuit. I have written more than 300 opinions and handled more than 2,000 cases. I have given it my all in every case. I am proud of that body of work, and I stand behind it. I tell people, don't read about my judicial opinions, read the opinions. I've served with 17 other judges, each of them a colleague and a friend, on a court now led by our superb Chief Judge, Merrick Garland. My judicial philosophy is straightforward. A judge must be independent. and must interpret the law, not make the law. A judge must interpret statutes as written. A judge must interpret the Constitution as written, informed by history and tradition and precedent. In deciding cases, a judge must always keep in mind what Alexander Hamilton said in Federalist 83. The rules of legal interpretation are rules of common sense. A good judge must be an umpire, a neutral and impartial arbiter who favors no litigant or policy. As Justice Kennedy explained in Texas versus Johnson, one of his greatest opinions, judges do not make decisions to reach a preferred result. Judges make decisions because the law and the Constitution, as we see them, compel the result. Over the past 12 years, I've ruled sometimes for the prosecution and sometimes for criminal defendants, sometimes for workers and sometimes for businesses, sometimes for environmentalists and sometimes for coal miners. In each case, I have followed the law. I do not decide cases based on personal or policy preferences. I am not a pro-plaintiff or pro-defendant judge. I'm not a pro-prosecution or pro-defense judge. I am a pro-law judge. As Justice Kennedy showed us, a judge must be independent, not swayed by public pressure. Our independent judiciary is the crown jewel of our constitutional republic. In our independent judiciary, the Supreme Court is the last line of defense for the separation of powers and for the rights and liberties guaranteed by the Constitution. The Supreme Court must never be viewed as a partisan institution. The justices on the Supreme Court do not sit on opposite sides of an aisle. They do not caucus in separate rooms. If confirmed to the Supreme Court, I would be part of a team of 9, committed to deciding cases according to the Constitution and laws of the United States. I would always strive to be a team player on the team of 9. Throughout my life, I've tried to serve the common good, in keeping with my Jesuit high school's motto, men for others. I've spent my career in public service. I have tutored at Washington Jesuit Academy, a rigorous tuition-free school for boys from low-income families. At Catholic Charities at 10th and G, I serve meals to the homeless with my friend Father John Ensler. In those works, I keep in mind the message of Matthew 25 and try to serve the least fortunate among us. I know I fall short at times, but I always want to do more and do better. For the past 7 years, I've coached my daughter's basketball teams. I love coaching. All the girls I've coached are awesome. And special congratulations to the girls on this year's 6th grade CYO championship team. Anna, Quinn, Kelsey, Shawnee, Chloe, Alex, Ava, Sophia, and Margaret. I love helping the girls grow into confident players. I know that confidence on the basketball court translates into confidence in other aspects of life. Title IX helped make girls and women's sports equal. And I see that law's legacy every night when I walk into my house as my daughters are getting back from lacrosse or basketball or hockey practice. I know from my own life that those who teach and coach America's youth are among the most influential people in our country. With a kind word here and a hint of encouragement there, a word of discipline delivered in a spirit of love, teachers and coaches change lives. I thank all of my teachers and coaches who've gotten me to this point, and I thank all of the teachers and coaches throughout America. As a judge, I've sought to train the next generation of lawyers and leaders. For 12 years, I've taught constitutional law to hundreds of students, primarily at Harvard Law School. I teach that the Constitution's separation of powers protects individual liberty. I'm grateful to all my students. I have learned so much from them. And I'm especially grateful to the dean who first hired me, now Justice Elena Kagan. One of the best parts of my job as a judge is each year hiring 4 recent law school graduates to serve as my law clerks for the year. I hire the best. My law clerks come from diverse backgrounds and points of view. A majority of my 48 law clerks have been women. More than a quarter of my law clerks have been minorities. And I've had far more African American law clerks than the percentage of African American students in U.S. law schools. I am proud of all my law clerks. I'm grateful for my friends. This past May, I delivered the commencement address at Catholic University Law School. I gave the graduates this advice: cherish your friends, look out for your friends, lift up your friends, love your friends. Over the last 8 weeks, I've been strengthened by the love of my friends, and I thank all my friends. I'm grateful to have my family behind me. My mom rightly gets a lot of attention, but a few words about my dad. He has an unparalleled work ethic and the gift for making friends with people, regardless of who they are or where they come from. My dad and I are both passionate sports fans. When I was 7, he took me to the 1972 NFC Championship game at RFK Stadium, just 2 miles from here. Upper deck, section 503, row 3, seats 8 and 9. When I was 17, we sat in the same seats for the 1982 NFC Championship game. In 1995, when I was 30, we were at Camden Yards together when Cal Ripken played at his 2,131st consecutive game and broke Lou Gehrig's seemingly unbreakable record. And so many other games with my dad. A lifetime of friendship forged in stadium seats over hot dogs and beer. My daughters, Margaret and Liza, will be in and out of this hearing room over the next few days. They are strong girls, dedicated students, outstanding athletes. In the time since you last saw them at the White House ceremony on July 9th, I'm pleased to report that Margaret's gotten her braces off and has turned 13. Margaret is the sweetest girl you'll ever know. As for Liza, I tell her every night that no one gives a better hug than Liza Kavanaugh. Finally, I thank my wife, Ashley. She's a strong West Texan, a graduate of Abilene Cooper Public High School and the University of Texas at Austin. She's now the popular town manager of our local community. This has not exactly been the summer she had planned for the family, but I'm grateful for her love and inspiration. Ashley is a kind soul. She always sees the goodness in others. She's made me a better person and a better judge. I thank God every day for my family. Mr. Chairman, Senator Feinstein, members of the committee, I look forward to the rest of the hearing and to answering your questions. I am an optimist. I live on the sunrise side of the mountain, not the sunset side of the mountain. I see the day that is coming, not the day that is gone. I am optimistic about the future of America. I am optimistic about the future of our independent judiciary. I revere the Constitution. If confirmed to the Supreme Court, I will keep an open mind in every case. I will do equal right to the poor and to the rich. I will always strive to preserve the Constitution of the United States and the American rule of law. Thank you, Mr. Chairman.
Thank you, Judge Kavanaugh. I have something I want to say to the committee, but before that, we've been here approximately 8 hours. You've had a lot to hear today and listen to. I think it's very noteworthy that no one has seriously questioned your qualifications to receive a promotion to the nation's highest court. And they've learned a lot about you being an exceptional teacher, coach, volunteer, and dad, in addition to being an exceptional judge. So I thank you very much for your statement. Questions for the record are due Monday, September the 10th at noon. We'll notice Judge Kavanaugh's markup meeting for Thursday, September 13th. This timeline is consistent with how we've handled past Supreme Court nominations. I want everybody to know that right now so that members and their staff can be working on written questions throughout the week. With that, we'll recess until tomorrow morning at 9:30, when we will start the first round of questions. Again, each senator will have 30 minutes for the first round of questions, and I intend to go like we have with Gorsuch, that people will have a chance to ask the questions they want to ask. But we start out with the 30 minutes and the 20-minute second round, so everybody's going to have a chance for 50-minute crack at this strong judge. Meeting adjourned. I'll start out, then Senator Hatch, because he has to go, and then Senator Cruz. There may be other Republicans come as well. We've had 8 hours of members of the committee have opportunities to make the points they want to make, and I think it's pretty clear that nobody has found any qualification problems with this particular nominee. It's all been on process. I think we've heard from the people who know Judge Kavanaugh, what sort of a person he is, and we know why he's so highly qualified to be on the court. And I expect that he will be on the court. Senator Hatch.
Well, thank you, Mr. Chairman. I've known Judge Kavanaugh for quite a long time and helped him on the Circuit Court of Appeals, where he has really established himself much better than some of his original critics thought he would. He'll make a wonderful justice on the United States Supreme Court. As you can see, his family's a wonderful family. They're religious people, they're decent, honorable people, they're certainly honest people. They're just the kind of people you'd like on the court, people who will treat everybody with fairness and intelligence. He's a very bright guy, and I look forward to having him go on the court, and I thought he did a very good job so far today.
Today was a good day. Despite the theatrics we saw, particularly in the morning, as the day went on, it became clear that not a single senator had raised any significant concerns about Judge Kavanaugh's qualifications to be a United States Supreme Court justice. Not only that, virtually every Democratic senator had little to nothing to say about Judge Kavanaugh's record as a judge, the over 300 published opinions that he has decided, the over 10,000 pages of published opinions over the course of more than a decade. That, at the end of the day, I think will decide this matter. Judge Kavanaugh is qualified. By any measure, he is one of the most respected federal appellate judges in the country. And the disagreements we saw today, the fireworks we saw today, stem not from concerns that Democrats raised about this nominee, but rather from concerns they would raise about any nominee appointed by a Republican president. Because the Democrats on this committee want to see the sort of nominee Hillary Clinton promised she would appoint, a liberal judicial activist who would impose the public policy outcomes they happen to favor. But that, at the end of the day, is not what the American people decided in 2016. In 2016, the American people decided resoundingly that we want to see a Supreme Court with strong constitutionalists who will honor the Constitution and protect our fundamental liberties, protect the Bill of Rights. That, at the end of the day, is what we expect of Judge Kavanaugh and every justice on the court. And at the end of this process, I remain confident Judge Kavanaugh will become Justice Kavanaugh and be confirmed to the Supreme Court.
Well, I can't add much more except to say that I thought today was very interesting about how you're going about trying to discredit Judge Kavanaugh. If you talk about his jurisprudence, there was literally no discussion today. I hope all of the discussion tomorrow will be about these 307 cases that he's written opinions on, or the dissents, and the legal mind that is Judge Kavanaugh. And I think finally, if you look at the introductions today, the broad spectrum of support that he received, It suggests to me that a no vote for Judge Kavanaugh is just a political vote, and I'll respect the other side of the aisle for doing that. I also want to take a moment to thank Chair Grassley for all that was said today about the process. If you take a look at the number of documents that have been received, the amount of time that was even provided today, the chair has continued his tradition in the 3.5 years I've been on the Judiciary Committee of being fair, being open, being transparent, and being patient almost to a fault.
Okay. We'll take a few questions.
Chairman Grassley, over the weekend, President Donald Trump tweeted that the Attorney General, Jeff Sessions, had put too easy...
I'll be glad to answer that question, but not now. Any questions on the hearing? Okay, thank you all very much.
Do you anticipate, Mr. Chairman, on the Democrats...
Republican members of the Judiciary Committee there giving a review of the day. Earlier, the committee chair, Chuck Grassley, mentioned each senator on the committee would get 30 minutes of questioning Supreme Court nominee Judge Kavanaugh in the first round and 20 minutes in the second. And that questioning starting tomorrow will have live coverage when the committee gavels in tomorrow morning starting at 9:30 Eastern Time here on C-SPAN 3.